Judge,
Yes.
what you always say about patience.
Oh, you need to put some in pocket and take it out as needed.
I knew you were gonna say that.
Oh, yeah.
You just said make sure you have some patience because I'll leave over here.
Mhm.
I already have my hand right here.
Oh, you got to be ready to use it.
Sir.
All right, everyone, just have a seat and we'll start in just a moment. But Sean, it's going to be a beautiful day. And you know, everybody needs to remember Mother's Day was yesterday, so they should still be joyful to all moms. So everyone, happy Monday. It's a day of new beginnings. Everyone, you're going to need some extra patience in your pocket, especially for those who have clients who are in custody because the elevators are down. So I've asked the deputies to bring them through a new route, but it's still going to take a little bit time. And just like the elevators are broken down for this court to bring inmates out, they're broken down in every court. So everyone be patient and we will move things as quickly as possible. Be extra patient with the deputies because it's not their fault that the elevators are down. Do you guys do elevator repair?
No, that's my check.
See, no, they don't do elevator repair. Some guy named Otis. Well, no, if you look on the elevators. All right. So I'm assuming nobody watched the movie with Hugh Jackman and Meg Ryan, where she goes back in time and she finds out that his uncle, well, not his uncle, the butler name is Otis. He's the one who's in charge of the elevator. So when you get in the elevator and you see the name Otis, but look up Otis and see where that comes from. All right. I'm going to call the docket. Everyone, please come in, have a seat.
First row is for late people, so please have a seat somewhere else if you're not late. Probation is for probation when you're called for probation. Please have your phones off or on silent, no recording or taking pictures.
Thank you, Deputy Laura. I just feeling in my bones that today is going to be a great day.
It's a great Monday, Judge.
It is. All right, we have Alejandro Chapa.
Present.
All right, thank you. Why do they have TDC as his location?
It's a probation matter.
Okay. Oh, I remember now. Thank you. In custody, we have Javier Zepeda. Kevin Young. Thank you. Roger Saucedo.
Present.
Thank you. Lawrence Jean Medellin.
Yes, Judge.
Thank you. Jose Del Bosque.
Present.
Thank you. Kenan Brown. Kenan Brown. Pedro Jesus Alonso. John Dominguez is in custody. Kenan Brown. Anthony Ray Miller. Thank you. Chardonnay Lockhart is in custody. Denver Stewart. Christopher Reyes.
Sure.
Tyler Small. Mario Miranda. Angel Roman. Jeremiah Escoto Martinez. Timothy Nichols. Timothy Nichols.
Honor, I was in contact with him last night. He's in McLennan County trying to get transportation. I texted him this morning. Can I return in about?
Did you say McClintock County?
McLennan County,
Ah, all right. I've driven through Waco. If he doesn't stop at an antique shop, he should be able to make it today. All righty.
Can I return that?
Yes.
Okay.
Leah Thompson.
Okay.
Jeremiah Thomas is in custody. Miguel Maldonado. Okay. See, everybody is being optimistic today. That's a good thing. I think he's going to be here too. Oh, now you changed it. Okay. Evelyn Oveda. Am I pronouncing that last name right?
Oviedo, yes.
Javier Esparza. Derek Reyes. Kiara Kilson. Kiara Kilson, KK. Sebastian De La Rosa, custody. James Earl Bradley. No, he's right there. I was about to say James Earl Jones. Young people don't know who that is, but I bet his parents do. Caleb Crumb.
Present with counsel, Your Honor.
Thank you. Alvino Acuna. All right, thank you. Are you the attorney who's on this? Okay. Travis Murphy is in custody. Todd Dotson, custody. Adam Hallen, custody. David Duenes. Thank you. How do you pronounce your last name? All right, thank you. Edward Murray. Summer Marie Muniz. Summer Muniz. Tevin Towns. Thank you. Christopher Trinidad, custody. William Franklin Tompkins. Katrina Ruiz. In custody is Eric Diaz. Michael Ball. In custody is Moses Maldonado. Juan Morales. Juan Gabriel Morales. Jorge Maciel Castro, custody. Patrick Vargas, custody. Kadir Gunner. Yes, I think he should be here, maybe. We shall see. All right, is there anyone who came in later, your name was not called? The jury is deliberating on your case. If you want to go to the cafeteria or something of that nature, you can. All right, anyone else? All right, everyone, these are the rules of the court. Number one, as some of you may heard, I don't know if there's some people here who are here for persons who are in custody, the elevators are down. So it's going to take the deputies a little bit of more time to get your parties here. So be patient. It's not the deputies' fault. They've told me they don't fix elevators, which they do not. That is not their job. That's somebody else's job. For attorneys, on this side is criminal trial division. On this side is family violence. Just pull your file, place your file down on the prosecutor's desk, have a seat. They will call you in order of appearance. Do not approach the court unless you've conferred with your client and conferred with the state. If your client does not speak English and wishes to have an interpreter, that means we need an interpreter here, whether you speak their language or not. Once an interpreter is called, please do not leave the courtroom because there's a shortage of interpreters and they need to be in other courtrooms as well. Once your inmate is brought out, do not leave the courtroom because for security reasons, the deputies can only bring so many people out here. Attorneys, you're gonna have to put some extra patience in your pocket and be extra kind today because everybody's gonna be, I know, hopefully not, a little bit frustrated with the inmates not coming out on time, but we're gonna deal with it and it's gonna be a great day. So everyone, be kind and confer.
He wasn't here. Mary, can I hold this? No, you have that.
All right, Jose Gilberto Del Bosque. All right, this is family violence. All right, today is your plea deadline date. Are you rejecting the plea?
We are, Your Honor.
Okay. All right, your plea deadline date has expired. What that means is the court will not accept any plea bargain agreements in this case without good cause. Otherwise, you'll have to plead open to the court. Do you understand?
Yes.
Well, I mean, do you?
Yes.
Okay. I mean, now's the time. If you don't understand something, please let the court know. There is no shame in not understanding. When we say we don't understand something and we let people know, that gives us a chance to explain. So do you understand everything?
Yes, ma'am.
Do you have any questions about the process?
No.
All right. Do you understand what it means when I say that your plea deadline date has expired?
Yes, ma'am.
Okay. All right, State, how long do you expect this trial to last?
Believe, 4 or 5 days.
Okay, why is it 4 or 5 days?
There could be several witnesses.
Okay. Is there more than one complainant?
Not that I know of, no.
Okay. So I'm thinking along 3 days, but if it goes beyond 3 days, then it'll go beyond 3 days.
And we're gonna go to the jury for sentence.
All right, is there alleged punishment?
Um,
Any criminal history?
No.
So
um,
then it shouldn't be that long. All right. Deputy Laura, do you know when we have impact? Caroline? Can you look and see when we have impact court? And I'm going to set you all the day we have impact. June 12th? All right, so we're going to reset you for June 12th.
All right, Judge.
Your Honor, the state would urge the motion to amend that should be on file, on the court's file.
Have you had a chance to review that?
Got it, Judge. No objection.
Have you read through it?
Yes, Judge. That's where they took the drug count out, just look with the alcohol. Remember, we were discussing the lab results from the PS on the gummies.
Okay. All right, we're going to go on the record. Court is calling 2021. Just one moment. Can you mute us? unmute us. And Caroline, you can already put their trial date for June 12th.
Yeah, I'll let him know.
All right, thank you.
Oh, you mean,
Yes.
okay, I'm sorry.
Oh, no problem.
Yes.
Yes, he's here. That guy's here. Unfortunately.
All right, Jeremiah Escado Martinez. Hello, you all were here for a PTD, is that correct?
Your Honor, we were here about a month ago when we got somebody to write on a file here that we were going to apply. The young man was told to apply. He filled out 3/4 of the online application and did not contact his big brother's big sister volunteer to help him finish it. And now we've come to find out the DA's office did not, the PTD division didn't hear from prosecutors that they had agreed to this, but thank goodness they wrote it in the file. So they are now in agreement to my asking for a reset so that the now properly filled out application can be processed. We
Okay.
wasted a month, but we're still very interested in doing this.
Well, time is never wasted if we use it to do good things, so,
We're progressing slowly.
okay. All right, so let me see. I'm going to recall you back on June 26th.
Your Honor, I'm 2 weeks from taking the longest vacation I've taken in
Oh,
30 years.
where are you going?
Hopping on a motorcycle by myself and going to Alaska.
Oh, you're riding on a motorcycle to Alaska?
Yes, Your Honor.
Oh my gosh, okay. So are you going to be camping and doing a journal, or what are you going to be doing?
I have a tent. I've been told the journal is old fashioned, that I should do a chat something or other on my
Oh,
phone.
like a blog or something, so we can see what's going on?
But, I tried to take pictures the other day and I was taking pictures of myself, so I'm not a computer.
Yeah.
I'm hoping to.
So how long is it going to take you to get to Alaska on a motorcycle?
Well, I don't know. The longest I've ever ridden is 300 miles, so this is gonna be a whole different thing.
Somebody, how far is it from San Antonio to Alaska? I'm interested in his travel plans.
5,000 miles.
5,000 miles?
Yes.
So how many miles are you going to drive each day?
At the beginning, not very many miles. I'm hoping I get better later. I'm still gathering stuff, today I asked for to have the AAA extended.
Mhm.
And I asked for my insurance to be extended to Canada. And I've had 2 people working on a particular route, so I have yet to decide what happens when I get to Canada. I know from here to there, I can probably do it out of my head, but in Canada, it's a completely different highway system.
Wow.
So
You should talk to Bettina, who was the court reporter for the 187th. She used to live in Alaska, and I want to say she drove to Alaska, at least she told me one time, through Canada.
yeah,
That's going to be exciting.
it's intimidating. I'm going to carry my own soap, but where do I put it?
Oh, well, where do you bathe? Are you just gonna bathe in the waters?
No, I think I'll have enough money so that I can stay in a hotel every night, but I'm not sure. I'm told that it's not guaranteed to have a hotel in Canada. So I'm bringing a tent and a sleeping bag. So I can't bring a weapon, so I'm buying a can of bear spray. So I'm just a lot of stuff, a lot of stuff.
Oh, so how long are you gonna be gone?
I've taken out for June and July, which is why I can't be here June 28th.
Okay. Ah, so you're taking off June and July.
Well, I'm hoping, hopefully I'll be back. The wife says I gotta be back sooner, but,
Okay.
I want to give myself enough time.
Oh, yeah, you got it. Well, you know what? Those are the type of trips that you get there when you get there, you stop where you stop and you just
I
live in
keep
the
telling
moment.
her,
Yeah.
And she tells me to call twice a day. I can't do that.
Oh, well, you have to call. Well, you're talking like somebody who's never watched a Lifetime movie.
I don't.
We call it the
avoid that
Suffering
channel, Your
Woman's
Honor. I
channel.
avoid that channel.
Well, no, you got to pick up the phone so people can say, hey, I last talked to him on Monday. You don't want somebody to say, find out you're missing and you've been missing for 4 weeks and they just find out about it, in week 10.
I know who I'm married to. There'll be lots of gadgets tracking me. I know they're gonna be.
Okay. All right. So this is what we'll do. I know you will not be here, but what we'll do is have your client come back on the 26th just to make sure that there's no issue with the
Absolutely, Your
documents. So you will be here. Your attorney will be traveling safely and going the speed limits in Alaska. And I always tell clients, because they think that attorneys shouldn't take vacation and some me time. When attorneys take vacation and downtime, they come back, they're refreshed and they're ready to continue. But we need some breaks sometime, okay? So we're gonna have you come back. Caroline, do you mind doing Norma, can you do a reset form for them for June 26th? So it'll be a PTD. Make sure you get all that paperwork in. And when you come back on the 26th, if there's some issue, we'll find out about it.
Yes, Your Honor.
All right, safe travels.
I should be back here several times before I leave.
Stop by post office and pick up stamps
I
and lock.
think I won't have a problem on that trip. Thank you, Your Honor.
All right, my mom always appreciates it.
825 miles.
8,825 miles.
4,000 miles.
4 different border crossings, 2 provinces, 8 states.
It's gonna be awesome.
I just hope I don't end up in bear food.
You're gonna be fine. All right, Norman, that's Jeremiah Escato.
Thank you.
You're welcome.
Yeah. You need to get this.
All right. Are you leaving? Mhm. Okay, can you call them and see when they could possibly get him here? Yes, yes. And you all want him here as opposed to Zoom? Okay, all right, thank you. Okay. And can somebody straighten Judge Angelini? His frame is tilted. All right, Michael Ball.
Jeremiah Martinez?
All right, can you call his attorney? All right, who's here for Michael Stephen Ball? Michael Stephen Ball. Kevin Oveda? Kevin Oveda? Yes.
Or Vera, Your Honor.
Yes, okay. Where's Oveda?
No.
All
My
right,
appointment did not have any contact information other than the address, which we already sent.
do you know, is he on a commercial bond?
I do not know, Your Honor.
All right, if you want to check and see if he's on a commercial bond, the bondsman may know where he is.
I will.
So if you want to call him and come back,
I will.
all right.
Thank you.
And actually, that may be the bondsman now. We don't know. We shall see.
Okay, then I'll wait.
All right. Are you on Evelyn Oveda? Okay. And Caroline, they're not ready on these two. Deputy Laura took the glass down, so now it's not like we're at a bank.
It's like throwing me off.
It is.
I was thinking of putting it right there.
Yeah, me too. I feel like something's missing. David, Winas? When, I'm sorry, how? Winas. Okay. Good morning. Council, you're wearing my mother's favorite color of blue. She loves royal blue. All right. Thanks for dressing appropriately for court. All right, so where are we on this case?
Judge, upon review of the case, it seems that they, CPS was involved in this case. Those records have been requested. We have not received them yet. So those are outstanding. And then through our communications with the complaining witness, there are some communications between her and the defendant that she indicated she was going to be sending to us, but we have not received those either. So there is still some discovery outstanding. I've let Mr. Martinez know that we'll be getting those to him as soon as we receive those. But I do believe this is the first setting in this case.
All right, Ms. Ferguson, on this case, can I have a 30-day reset, please? And it'll be for discovery. Well, you know what? Actually make it 45 days because there are CPS records involved. Do you know if the CPS attorney actually has the records and you all just need to get them, or they're in the hands of the department and not in the hands of a prosecutor?
I believe that they're still in the hands of CPS and we have not received that.
All right, so 45 days, Ms. Ferguson. All right, we'll be back on July 5th. Don't get hurt by any fireworks, but do not leave before you sign the reset form.
Can you get back in front for a second?
Sure. Let me just find your client on the docket. Just 1 second. There he is. All right. Yes.
Judge, I think we filed a request to change the GPS from partial to tracking. Mr. Duenas is a car salesman and he works very long hours. And sometimes he has to actually leave work in the middle of sale because his time is running out. And so.
Well, we have another issue. The other issue we have is there's a violation of a bond or protective order from December 31st, 2022.
We just found out about that, Judge, and he actually surrendered last week to clear that warrant. It was filed at large just in April.
All right, so we're not on the record. What's the issue? Mr. Jonas, do you understand you're not to have any contact? Did you not understand that before?
I don't recall the incident, to be honest with you. It was on New Year's. So I was, yeah, I don't recall. But
All right, so,
It's an allegation of.
Yeah, yeah.
Right. so you need to call the complainant now. Ask her if she's aware that Mr. Jonas is not to have any contact with her or Christian. And if there's an issue with that.
I will mention.
And well, that needs to be done now because the court has a violation report that I need to take up now.
Okay.
So if you can call her and counsel, if you want to be involved in the conversation, I need to know if she's afraid of this person. I need to know if she can zoom in so that we can discuss this so everybody can be aware of what the conditions of bond are. So before I even consider changing GPS for work, let's see if we can get her in here by Zoom. Deputy Laura, could you give them the Zoom link? And let's see if the complainant can zoom in so I can figure out what's going on here and make sure that there are no violations. Because if there are violations, what will end up happening is, regardless of what the misdemeanor court does, I could still put you in custody. You understand? So I want to make sure that everybody is on the same page. So what we're going to do is you're going to get the Zoom link, have the complainant zoom in so we can find out what's going on. And when I say we, I mean me.
Can I step out, Judge?
Yes.
Norman has my phone to text me if once they're ready to.
All right, thank you. Anthony Miller. Hi,
Good morning.
good morning. How are you doing?
I'm well. How are you?
Oh, I'm doing great. It's Monday. Everything is good.
Good. And it's a happy Monday.
Yes, it is. All right. So we have the acknowledgement of discovery filed and signed, and I think that was done with Judge Angelini. So where are we on? Did he receive an offer?
Yeah, no, we did receive permission to apply to pretrial diversion.
Okay.
Which we did in the last setting. And we're just awaiting it. It's been accepted. We're waiting review. Pending outcome.
All right. Ms. Ferguson, I need a PTD date on Anthony Miller.
Can I do July?
Yes. All right, so we'll be back on July 5th.
Yes, ma'am.
And I understood that you had a funeral to attend.
That was when I was like first like being like aware of this and stuff. Yeah. My girlfriend, she's right there in the back. That's who we're going to visit her grandpa for the funeral and stuff, but I didn't end up making it.
Okay, no gum in court.
Oh, sorry about that. I ain't know.
That's okay.
I'm not used to these rules.
No, no problem. All right. And I see the Vietnam,
Yeah, that's from my grandpa. He was a Vietnam vet. He died when I was in 8th grade.
okay.
Yeah, that's right.
All right. Well, Ms. Ferguson will give you the reset form and we'll see you back. Make sure that you do everything that's required of you on PTD, okay?
Yes, ma'am.
All right. Thank you.
All right, thank you.
Thank you. Thank you. Good seeing you.
Same here.
Oh, no, I'm not worried about that.
Yes.
Sheets.
Oh, do patience, do patience. Oh, well, there's, you know what, there's always a reason for it, and it's probably a good reason your computer is down, because now we can call IT and they can see what's going on. Okay. All right, are you ready on Del Bosque?
Yes.
All right, if the parties could come forward on Del Bosque, please. All right, the court is calling 2021 CR 10255, State of Texas versus Jose Gilberto Del Bosque. We have parties announced for the record for the state.
Travis Banks, the state of Texas.
For the
Eric
defense.
Schreck for the defendant.
And are you Mr. Del Bosque?
Yes, ma'am.
All right, the state has filed a motion to amend the indictment. Counsel, have you had a chance to review that document?
I have, Your Honor.
And have you a chance to review it with your client?
I have, Your Honor.
Do you have any objections?
No objection.
All right, then the court will grant the state's motion. All right, just make sure you sign the reset form for jury trial.
Thank you, ma'am.
You're welcome. And Norma, they're set for jury trial for June 12th.
Yes, ma'am.
And Judge,
Yes.
Mr. Ball, I was doing paperwork with Ms. Lockhart. So I did not hear his name being called.
Okay.
He's
All
been
right.
in here too. so-
Okay, no problem. I'll take it up.
Thank you. Do want you to think I was ignoring you.
Oh, no problem. Just have the clerk pull it.
She did, she handed it to you.
Okay, all right, thank you. Oh, yes,
Judge, may I approach?
yes.
You know, I checked my notes and it's PR bond, and I've reached out to PR bond to see if they have any other information about other than the one that I received through the appointment.
Mhm.
But they haven't gone back to me,
Okay, and who's your client again?
Mr. Olivera. Well, Evelyn Olivera.
All right, if you'll have them pull the file again, and then I'll take it up.
Thank you.
Oh, she's already pulled it. All right, the court, and this is Criminal Trial Division, court is calling 2023 CR 2521, State of Texas versus Evelyn Crystal Aveda. And Deputy Laura, have you made an announcement outside?
Yes, Your Honor, there was last.
Okay. All right, can I have parties announced for the record in 2023 CR 2521, State of Texas versus Evelyn Oveda?
Daniel Escobar for the state of Texas.
Jose Rocha from Ms. Olivera.
All right, this hearing was scheduled at 9 a.m. It's now 9:48 a.m. Defense, have you had any contact with your client?
I have not, Your Honor.
All right, and Deputy Laura, you said you made an announcement,
Yes, Your
and was the defendant, well, did the defendant answer?
Honor.
All right, state.
Your Honor, stated this time would ask for a bond forfeiture.
All right, the court will issue a judge's warrant, remand your client without bond. If she makes an appearance, then the court will reconsider.
Thank you, Your Honor. I
right.
appreciate that.
Thank you, you're excused.
Thank you, Your Honor.
All right, who's here on Michael Ball? All right, thank you. Yes, please. All right, on Michael Ball, what's happening with this case?
Judge, we received an offer from the state. We are waiting for a little additional discovery, some of the pictures in this case, and we'd ask for a reset to consider.
All right, what is the discovery that's needed?
Pictures.
Okay. State, are those uploaded?
They have not been uploaded. We have not received them from BCSO yet, Your Honor, so I'll have to reach out to get those.
All right, Ms. Ferguson, can I have a 30-day reset for discovery? All right, so you're going to be reset for June 15th. Once you sign the reset form, you're excused.
Thank you, Your Honor.
You're welcome. And on this one, they're not, they're waiting for the complainant. All right, who's here on Chardonnay Lockhart?
Please, Your Honor, we're ready.
Right. All right, if parties can come forward. Court is calling 2022 CR 3597, State of Texas versus Chardonnay Leanne Lockhart. Can I have parties announced for the record for the state? Defense,
Andrew Frederick from Ms. Lockhart.
are you Ms. Lockhart?
Yes.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Lockhart, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
I'm going to show you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
I am a female. You keep saying, yes, sir.
No, I said yes, Your Honor.
No, you said, yes, sir.
Said yes, Your Honor.
I would
Okay.
say- I heard yes, Your Honor, as well, Judge.
Okay. All right, are you proceeding on the,
1 month.
are you proceeding on the indictment as presented?
Judge, we're gonna go with the lesser included offense of attempted arson, recklessly causing damage.
Okay. Any objection?
No objection.
All right, I'm going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
All right. Oh, you're right. She did say yes, Your Honor. I don't know why it sounded like sir. My allergies are really, I apologize. My allergies are really acting up today.
And Judge, no, I whispered to her that she needs to speak up and not see it. So she knows.
Okay, that's okay.
Thank you, Your Honor.
Because sometimes people always say that and I'm like, what? All right. Did you understand the state is proceeding on the lesser included offense of attempted arson recklessly causing damage as a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
Actually, Judge,
I believe, Judge, since it's attempted, the arson recklessly causing damage is a state jail, and since it's attempted, it's a class A misdemeanor.
Okay, why do you guys have this filled out as a state jail?
It should have been
the
changed.
first paragraph specifically should list it as a class. A.
All right, so you all need to redo this piece of paperwork.
Sure.
And I would suggest that you use the felony paperwork. That way you can write it in, because otherwise
It's difficult.
I don't have knowledge that she knows that it's a class A, because that's not how it's listed.
That first paragraph I wrote A right next to it. That's my handwriting. First page, Judge, and it says range of punishment, and it listed up to a $4,000 fine up to a year in jail.
Oh, okay, you are correct. Look at
Every
this.
once in a while, Judge.
Corrections are happening. I appreciate it.
I hate to correct you, Your Honor.
That's, no. Here's the thing. I always tell people,
Sounds good.
make sure that if I'm saying something that's incorrect, to let me know, okay?
That's what we did there.
All right, so this is what I'm gonna need you all to do, though.
Yes,
I
Judge.
need her to initial it, so I know that she knows, because all of this is state jail felony paperwork. That's why I say
Okay.
state jail.
Sorry about that, Judge. I saw that. I thought about using the other paperwork, but I didn't know if that was probably the better way. Or from now on, I'll probably try and do that.
Okay. Because all this paperwork is state jail felony paperwork.
I tried crossing out, it was the felony, the discussion about the felony, the felony in possession of a firearm. And I thought I caught everything else. I think I changed everything to look like.
Yeah, we
Okay.
erased all of the stuff about the firearm possession because that doesn't apply because it's not a felony.
Okay, let me carefully read through the paperwork. Just give me a moment to make sure that everything is the way it should be. All right. All right, so we're back on the record. All right, they're charging you as arson as a class A misdemeanor. The range of punishment for that offense is up to $4,000 fine and up to a year in a Bexar County jail. Do you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court only has the authority to sentence you up to 1 year in the Bexar County jail and up to a $4,000 fine?
Yes, Your Honor.
All right. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
If I could answer a little bit more, Your Honor. Yes, I do believe she does. She's mentally competent. She was done a psych evaluation for competency a few months ago. She has been found competent after discussing the case with her today and last week as a jail visit. I agree, she is competent.
All right. So she's already been to the magistrate's court and they've deemed her competent?
That's correct, Your Honor.
All right. Do you believe she was sane at the time of the offense?
Yes, Your Honor.
Ms. Lockhart, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
All right, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Okay, according to the plea, the state is proceeding on the lesser included offense of attempted arson recklessly causing damage. They're recommending deferred adjudication. They're taking in consideration County Court Cause number 6348806, and there's to be a MIC evaluation. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There you are.
Next, I'm showing you outside the plea bargain agreement. State is recommending that your deferred adjudication be for a term of 2 years and there be a TAP evaluation. Did you understand?
Yes, Your Honor.
Okay. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
All right, then to the offense of attempted arson recklessly causing damage, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offer state exhibit 1 in all attachments.
No objections.
Right. I'm going to show you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yeah.
All right, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Sure.
Anything you wish to say on behalf of your client?
That's the follow the plea bargain.
All right, Ms. Lockhart, if you're released from custody, do you have a place to live?
Yes, Your Honor.
Where?
738 Morris.
No, I'm sorry, don't say the address,
Oh,
but who will you be living with?
I apologize. It's a property my father had bought.
Sorry, what?
I'll be living by myself.
Well, whose property is it?
My father.
Why were you not living with your father before? During this incident?
No, it's because I'm 30 years old.
Well, no, here's the thing. I'm reading this and it appears, rightly or wrongly, the way I'm reading it, it appears that you were homeless. It says that you started this fire because you were trying to dry a blanket. So I'm wondering why you were not living. Well, no, that's what they say you told them. It's in the police report. So I'm trying to figure out why were you homeless and why would your father let you live with him now?
Judge, if I can just have a second.
Here's the thing, Ms. Lockhart, you need to be honest with me, because I'm trying to figure out your conditions. And let me just tell you, one or two things are gonna end up happening. If I don't believe you're gonna be honest with me, this is gonna be set for a PSI. You're gonna be sent back to Bexar County Jail. They're gonna do a PSI report, and I'll get it when I get it, which will probably be within 8 weeks. So you need to answer my questions, and you need to answer my questions honestly. Now, in this police report, basically, it's implying that you were homeless because it said there were clothing and other items, and that you lit this fire because you told them you were trying to dry your blanket. So this is what you stipulated to. I didn't force anybody to stipulate to it. That's what's in the police report. So why were you homeless if now you can live with your father?
I wasn't at home, but I was not homeless.
So why were you living in this field or wherever it was with your items?
I have no idea. I don't know how to answer that.
All right, so why is she wearing yellow today?
I'm pregnant,
Okay, I just wanted to hear it. And how far along?
like 21, 22 weeks now.
Judge, I didn't mean to be presumptuous, but I have been in this court once or twice before. I did tell her she was going to be taking a parenting class, which was theoretically outside of it, but she understands she's going to take the parenting class going forward. Because that's going to be her.
All right, and is she on medications at the jail?
Yes, Judge, she was not on her medication at the time. Now she is on her medication. She's frankly alive. She's definitely competent at this point in time. At the time, she was not being rational, but at this time, she is going to be successful going forward. There is the part about the mental MIC caseload and her being interviewed for that. I believe that would be necessary. And she understands that being med compliant is going to be a part of that as well.
All right, do you have any other children?
Yes, I do.
How many?
2
And where are they?
out of town with my family.
And what are their ages?
11.
They're both 11, twins? That's either yes or no.
Yes.
All right, this is what, is there anything else from either side? Do you know if she's receiving SSI now?
I don't know.
All right, I'm gonna sentence you to 2 years deferred adjudication. I'm gonna want felony drug court referral. They should be able to do it because it's 2 years. And I'm gonna want a MIC evaluation. Those are to take place while in custody. And then I'm gonna want a referral. If she's not approved to MIC, I want a referral to Center for Healthcare Services, parenting classes. Take in consideration County Court Cause number 634806. 80 hours of community service restitution. Once she completes parenting, that will be satisfied. Regular reporting by Zoom or in person. Regular UAs. And I'm gonna want a TAP evaluation in custody as well. If TAP recommends inpatient treatment, we'll start her with intensive outpatient treatment. And I'm gonna want field visits. 1 time per month until further notice. Probation. We'll do proof of employment within 30 days of release. Or proof of SSI within 30 days. There's to be no employment as a home health care provider or with minors. And I'm sorry, instead of the regular UA's probation, I'm gonna want the UA hotline with testing at least once a week. Probation, is there anything else she needs? Is there anything else you need from the court to be successful?
No, Your Honor.
Counsel, do you think there's anything else your client needs?
There's nothing else she needs, Judge. We asked the evaluations be done when she's out in custody.
All right, that will be denied. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, yes.
All
sir.
right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Right, yes, Your Honor.
All right, we can go off the record. Was she not approved for mental health court?
Honestly, can't tell you off the top of my head, Judge, since she's been in custody this time.
Mhm.
We've conferred with the DA and this is the attempt. She's got quite a bit of time. So this is our agreement that we reached.
All
If
right.
she was approved, I know that she's being evaluated for mental at the MIC caseload.
Mhm.
Being that it's a misdemeanor, but mental health court, I don't think that was approached because it didn't. There wasn't an option to be a misdemeanor until we talked about the last week.
All right, probation, can you also do a referral to the mental health court? And see if they'll accept her. My understanding, mental health court, it's sort of like PTD. So if they accept her and she completes it, then this will be as though it never happened. So counsel, if they accept her in PTD and you all want to come back and ask for a motion for a new trial or withdraw her plea,
Yes.
then the court will consider that.
That's what I was thinking ahead, Judge. And that's why my brain was going like, I don't know if it looked like I was rolling my eyes. But I was like, does that mean that she wants? Yes. Okay.
All
I'll
right,
explain that.
so,
Thank
Rashawn,
you.
if you can, you're welcome. Rashawn, if you can make sure she's referred to mental health court and tell them that even though she's entered a plea here, if they're willing to accept her, defense is going to file a motion for new trial and the court will grant it. All right, thank you. You're welcome. Have a great day.
Thank you.
And I'll explain in a second what she's doing and really helping her out. But,
All right, and they'll put you back in the box so probation can speak with you, okay?
Yes, ma'am.
All right.
Thank you.
Mario, you're welcome. Mario Miranda. No, she has probation, needs to speak to her.
Good morning, Your Honor.
Good morning. It's always a pleasure to see you,
Good to
Mr.
see you, Judge.
How's everything going? How's the wife doing? Oh, that is
Better.
awesome.
Picked
All right.
up her spirits. She had real nice red roses yesterday.
Oh, that is so awesome. All right, who's the prosecutor on Mario Miranda?
Yes, ma'am. Yes, ma'am.
It's aggravated assault.
Travis Banks here for the state of Texas.
All right, Mr. Miranda, today is your plea deadline date. So are you accepting or rejecting the plea? Do you want a jury trial?
Judge, it's a plea deadline day, but we came up with a possible new witness that may change the state's position on their plea offer.
Okay.
We get maybe 10-day off that may work and save us a trial.
All right, Ms. Fergus, can you recall this for May 30th?
Yes, ma'am.
All right, May 30th, that will be your last plea deadline date.
Thank you for your consideration.
All right, the court will not extend any further.
Yes, Your Honor.
All right, Ms. Ferguson will give you a reset form, then you're excused.
Thank you.
All right, you're welcome. All right, here you go. Can you have the court reporter? I need the court reporter who was here.
Miss Mary.
Yes,
On the computer, we can do it this morning or the afternoon.
as soon as he comes.
That's fine.
And Norma, can you call the attorneys?
Yeah.
And their client needs to be here.
Questions? Mr. Leal is down there.
All right, Mr. Leal. There are questions from the jury. Prosecutors on Juan Antonio Garcia Sanchez. And if you all will pass those back to me after you review those. Caleb Crum. Who's the attorney for Caleb Crum? Oh, counsel, if you all can step back. All right, so what is happening on this case?
Judge, we've conferred today. There are some records from CPS that are included as a notice of additional discovery. I'm going to be filing the motion to release those to me, of course, with the protective language within them.
Well, do they have the records?
They do.
Oh, well, they can just hand the court the form and you can, and they can turn them over now. Is there a reason why it can't be turned over now?
Travis. Sorry. Do you have the CPS form that we have right now?
It's around.
We'll get that now, Judge. I didn't realize there were one here in the court.
All right, so did the state make an offer to you or no?
They did, however, one brief last update.
Yes.
I've brought to Travis's attention today some potential grading. I'm going to be getting him an adult protective services case number involving the complaining witness on this case. So once he has the case number, is going to be reaching out to APS to get those records for us. I think it is instrumental in the defense based on some of the family interactions in this case. But we did receive an offer today. I've conveyed it to my client. We're not accepting it as of now. I don't know the turnaround for APS, but I'm going to get him the case number as quick as I can, hopefully as soon as this afternoon.
Oh, I dealt with APS. They're pretty quick on their turnaround.
Absolutely.
All right, is your client okay?
Yes, Your Honor, sir.
Oh, yes, ma'am.
I think he's just nervous.
Okay. All right, Ms. Ferguson. On Crum, can I have a 30-day reset for discovery?
That should be fine.
All right, Mr. Crum, when you come here on June 15th, the court may be requesting a drug test. You understand?
Yes, ma'am.
So is that going to be an issue or a problem?
Can I touch my attorney back about something?
All right, so here's the thing. I like for people to have clear heads. And we're not on the record. So if you're going to be positive today, then that means that you need some help.
I have medical municipal marijuana or whatever it is, the CBD oil. I've been prescribed for my seizures.
Well, you need to supply that with your counsel, because otherwise we're going to have an issue if you test positive. You understand?
Yes,
And
ma'am.
for what it's worth, Your Honor, it is mentioned within the state's file that it does have seizure medications. Was it seizures or? What's the one where you see blinking lights?
Oh, I know.
Epilepsy, yeah, I was blanking on it. So it's within the state's file that there are some medical issues, so I have no reason to doubt my client. He's been forthright about everything.
All right. So,
And if you need, I can see if I bring the paperwork too, because I guess the CBD oil that I'm on has THC and my doctor was saying it already would show a positive on my drug test.
well, here's the thing. If you are using marijuana, because you're not allowed to use any type of marijuana,
I
on
understand.
bond or anything like that. So you need to make sure that your attorney has those documentations so that he can provide those documentations to the appropriate departments that are overseeing your bond conditions. You understand?
Yes, ma'am.
All
I'll get
right.
them and I'll reach out to his doctor.
All right, so we'll be back on June 15th. Just get a reset form.
Thank you, Your Honor.
And I've signed the motion for the records to be released.
Thank you, Judge. I appreciate it.
You're welcome.
Are you gonna upload it or should I stop? The revocation?
All right, and you can call Judge Mason. And let her know that we have an issue. All right, who's here? Miguel Maldonado. You can make sure your client comes up.
Yes, Your Honor. Been waiting for it.
Okay, just give us a moment, okay? Thank you.
Oh. Yes.
Just one moment, counsel. Who's here on Maldonado? Could Mr. Maldonado come up?
He's not here, Your Honor.
Oh,
That's why I'm approaching.
all right. Is he on a PR bond?
I don't know. I would think not, but I don't.
It's 2023 CR 2432. All right, court is calling 2023 CR 2432, State of Texas versus Miguel Maldonado. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
All right, for the defense?
Thomas Beck for the defense.
All right, this hearing was scheduled at 9 a.m. It is now 10:17 a.m. Deputy Laura, did you make an announcement for Miguel Maldonado?
Yes, Your Honor, I did, and there was no answer.
All right, defense, do you have any idea where your client is?
No judge. However, I talked to him this morning very early.
All right, state.
Judge State would be asking for a bond forfeiture.
All right, the court will issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider.
Okay, Judge, I have a lot of discovery to review. I'm not on this case, on some cases set on Wednesday, so I would like to be excused, but I
Oh, no,
don't.
you can be excused. I mean, if your client makes an appearance, then the court will reconsider the
You'll-
judge's warrant, but for now. there's a
Okay,
judge's warrant.
and if you do reconsider, you'll set it for trial.
We'll see.
Okay,
We'll see where we are.
okay, thanks a lot, Judge.
You're welcome.
Judge. Not Friday.
Oh, so cute. What's the puppy's name? Ah, Bruto. I like it. Bashan? Your dog may be having a competition for cuteness.
No, sir.
But
So
yeah,
they have a new puppy.
we got him on Saturday, and so it's just one of those things where we've been trying to adjust so far, so.
Oh, wow. All right, can I see the attorneys on Juan Antonio Garcia Sanchez in the hallway for a moment, please?
On the whole.
Oh, yeah.
No, I'm reading that new.
Albina Cuna. Pierre Silken. Juan Morales. Timothy Nichols.
Now, if you all can come forward, please. And if I can have your client. come forward. Oh, we need an interpreter. Norma, can you have an interpreter come down? Yes. Sorry. Let's get the interpreter. Who's here? William Tompkins.
I'm your honor.
All right, Mr. Tompkins. All right, where are we on this case? And this is family violence.
Yes, Your Honor. We have conferred, we've received an offer, but at this point, I don't believe there's going to be an offer that we accept, and
All right, have you received all the discovery?
I believe so.
All right, Ms. Ferguson, can I have a 3-week reset on Tompkins, please? And that's our plea deadline date?
I can do,
All right, we'll come back on June 12th. All right, and that may also be a jury trial date, okay?
All right. Thank you.
All right, just get a reset form for Ms. Ferguson, then you are excused. And Ms. Ferguson, we'll do that as a plea deadline date and jury trial date. Who is here on Angel Roman? Ramon? Angel Ramon? We're waiting for your attorney.
Same with the report.
All right. All right. Who's here on Derek Reyes? All right. Good morning. Always good to see you.
Good.
All right. What is happening with this case?
So Judge, it's a first setting post indictment. I did sign the discovery acknowledgement this morning. Mr. Luis Martinez is the first chair and he is in trial in Kimball County this morning.
Okay.
We don't have an offer quite yet. We did do some conferring this morning, Judge, but would it be possible to have a setting for, I guess, discovery deadline or plea bargain?
All right, Ms. Ferguson, can we do a regular reset 1 month, please? On Derek Reyes.
I can do the 20th.
The June 20th?
Yes.
All right, so we'll be back on June 20th.
Thank you, Judge.
You're welcome. Just get a reset form from Ms. Ferguson, and then you can be excused.
Do that. Thank you, Judge.
You're welcome. And there's a Janessa Gonzalez in the waiting room, so I'm assuming that's with Mr. Yes. Edward Murray. And we'll take that up after we take up the jury trial matter then. And Norma, can you let Mr. Martinez know? All right, this is Criminal Trial Division. What is happening with this case?
Good morning, Your Honor. The state just offered, tendered an offer, and I spoke with my client. We just, the discovery is rather voluminous. There's a lot of video footage. We just asked for a little bit of time so that we can consider all the aspects of the case before accepting or countering this offer.
All right, Ms. Ferguson, can I have a 30-day reset on Murray for discovery? All right, we'll be back on June 15th. Just sign the reset form and then you will be excused.
Thank you, Your Honor.
Thanks for dressing appropriately for trial.
Welcome.
Who's here on Alejandro Chapa? All right, just so you all will know, we will start, but if y'all could just give me a moment, the interpreter just came in. Thank you for coming down so quickly.
Oh, you're welcome, you're right.
All right, could the parties on Juan Antonio Garcia Sanchez come forward, please? All right, thank you. Court is calling 2019 CR 6322, State of Texas versus Juan Antonio Garcia Sanchez. We have an interpreter here. Could you raise your right hand? Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English? So help you God.
I do, Your Honor.
All right, you can lower your hand. If I could have parties announced for the record for the state.
Ruben Herrera and Travis Banks for the state.
Defense.
Rafael Leal and Brian Kimball for Juan Antonio Garcia Sanchez.
All right, and are you Juan Antonio Garcia Sanchez?
Yes.
All right, the court has received 3 questions from the jurors. First question, what are the dates of his unemployment? Both state and defense, have you had a chance to review that question?
Yes, sir.
The supplemental charge will read as follows. Members of the jury, I have received your note. Under the law, I cannot read testimony back to you generally. You must have a dispute about the testimony that you are asking about, and you will need to specify exactly what you are in dispute about. If the jury specifies as to what they are in a disagreement about with regards to the statement of any witness, then they may, upon application to the court, have read to them from the court reporter's notes just that part of such witness testimony or the particular point in dispute and no other. Is there any objection from the state to that being the answer to the question?
No objection from the state.
Defense,
No
any
objection.
objection? Next question. Do we need to have a specific incident for each charge date because we only have 3 examples? Answer. With reference to your inquiry, you have all the law before you. Please continue your deliberations. Any objection from the state?
No objection.
Defense. Next question. Can we consider the Mexico incident, which would have happened in 2014, 2015 as one of the charges? For example, February 2017. Answer. With reference to your inquiry about whether you can consider the Mexico incident, you are instructed that you are not to consider it. Any objection, state?
No objection.
Defense.
No objection.
Any objections to the court sending the answers back to the jury, state?
No objection.
Defense.
No objection.
All right, the court will have the deputy send the questions back to the jury with answers. All right, thank you. If you all will have a seat and we'll see if there are any more questions.
Thank you.
Thank you. Thank you for coming down so quickly.
You're welcome. My pleasure.
All right, and Normie, could you make sure Mr. Martinez, because the witness is here. Okay, all right, thank you. All right, Mr. Porter and to the state, do you all have witnesses on Alejandro Chapa? Do you have witnesses on Alejandro Chapa? All right, if you all would come forward. All right, the court is calling 2016 CR 3792B, State of Texas versus Alejandro Chapa. Excuse me, Mr. Leal, if y'all can move down there because you're behind the court reporter. All right, court is calling 2016 CR 3792B, State of Texas versus Alejandro Chapa. Can I have parties announced for the record for the state?
Stacey Harrington.
Defense.
Robert Porter for Mr. Chapa.
And are you Mr. Chapa?
Yes, ma'am.
All right, we are here for sentencing. In this case, the jury found you guilty on some counts, I believe. And on some, you were sentenced to prison.
Yes, ma'am.
On others, they sentenced you to probation.
Yes, ma'am.
So it's the court's understanding that you serve your prison sentence, and now we're here to address the issues for probation. Is that correct? All right. The court ordered a PSI report to be done. Have you all had a chance to review the PSI report?
I personally have not. Mr. Lunan, I believe, has, and he can't be here this morning.
All
Judge.
right.
I
Would you
apologize.
like to review the report? Thank you, Judge. Sure. All right, and yes, I think this is the correct one. Probation, did you have one?
No, Your Honor.
This is what I have in my file.
Is this from 2016? Oh. Then David. And that's fine, Judge. We can proceed.
Okay. All right, so let me see which counts.
This counts 1, 3,
I'm sorry, counts, you said counts 1
3, and 11.
and 11. All right, and let me just find their judgments to see what,
Also, the court has looked at this briefly.
yes,
Looking through the court's file, we did find that the sitting district court at that point in time, I believe Judge Hilda had already ordered conditions.
so are you in receipt of that?
And the state would agree with that, Judge. We've seen those conditions of probation that were originally signed. Those are in the court's file. Those were signed at the time of sentencing. That the conditions of probation were already ordered and signed by the court and by the defendant himself.
Okay, so that's counts 1, 2, and 3.
1, 3, and 11.
I'm sorry, 1, 3, and 11.
That's correct. And some of the judgments don't reflect the correct sentences, and the state will have to do a non-proton motion on that to fix some of the judgments.
All right, so then the only issue is with regards to reporting. I usually order the different things when people are on probation, but if Judge Hilbig has already ordered conditions, I'm not going to interfere with his orders unless there's a reason to interfere with his orders. Okay. Just one moment off the record. Attorneys for this jury trial? Raphael Leal. The next question the jurors have is, could Mia have dropped the charges after the outcry? So here you are. And I'll send an answer back. All right. So we're back on the record. Thank you all. Sorry for the interruption. So state you believe there are some issues with the previous judge's orders or issues with the judgment?
Well, the judgments, I think one of the judgments doesn't reflect, at least one of the judgments doesn't reflect the correct number of years sentenced. And possibly 2 of the judgments. I think they all say 8 years, but that's not correct.
Okay.
Giving you my whole life.
Thank you, because this is a thick file.
Count 1, this is count 3 and count 3 of the judgments themselves, and what the judgments all reflect is that Mr. Chapa was sentenced to 6 years. And going through the court's file and stuff, we did find out, and I think the court's going to find out that it was a clerical error that one of them. The count 1 is a 6-year TDC. Count 3 was actually a 10-year TDC.
Okay.
And count 11 was an 8-year.
Okay, yes, I do see count 1 is 6, count 3 is 10. And then count,
11.
I'm flipping through pages. And then count 11 is 8 years.
Correct, but all the judges itself is like 6 years.
Okay.
So
All right, we can, I think,
Do a non-pro tempore, I imagine.
all right, Caroline, will you be able to correct those? Because the judgments are off.
Yeah.
Yeah, so we'll get that done for you.
Okay, Judge.
All right, and then I'm assuming I'm assuming Judge Hilbig ordered reporting.
All of the conditions are on there, Judge. I do know that, I did notice that, sex offender was ordered. I think specifically, what, was the hope of Mr. Lennon was that the, sex offender unit, be ordered. He was hoping that among those conditions that he would be restricted, internet access and some kind of evaluation and treatment that would, address the mindset that allowed him to believe he could use his power as a police officer to manipulate women for his own sexual purposes in this.
Well,
case.
it's ordered that he be in the sex offender program. And I think part of that program relates to internet access and treatment.
And he's already signed up, Judge, on release from prison. He's already engaged in all that. Everything he's supposed to be doing.
All
And we
right.
just wanted to make sure that was covered. Judge.
Yes. And then he'll have to do the reporting. And yes, you're gonna have to register. You understand?
Yes, that's already completed.
Okay. And probation, is there anything else?
No, not at this time, Your Honor. We will ensure that the case is active on our end. And I've already given him some contact information, so I'll just make sure we have everything up to date.
Okay, and then the clerk will correct the judgment.
I think the only other question that was remaining outlying was we know that he has 10 years of probation that he has to be on for. But should there be any issue with his probation, should he have to come before you for an MTR? Is what his underlying sentence would be that he would be facing should he be revoked?
Oh, exactly what's in the
Right.
the judgment from the jury. So where the jury says 10 years, then it's 10 years. Where they say it's 6 years, it's 6 years.
And it is my understanding also that when he went to prison, although he's not getting credit for the time in prison, he is getting credit for time in probation. So his probation is only going to be for 4 years, not the 10.
Yes. And so the date from probation, because the judge entered the judgment on that date, the 10-year sentence starts from the date that the judge entered conditions of probation. Yes, counsel. All right, so in this courtroom, communication is key if you want to be successful on probation. If there are any questions, ask your probation officer. If you feel as though your probation officer is not addressing those issues, then Ms. Abrams will tell you we're in court Monday through Fridays, not really Fridays. We try not to be, but I'm here Monday through Friday. And you can always address those issues. And of course, you can always contact Mr. Porter if there's an issue. There's to be no drug use. And I'm very serious about no internet use. And so you need to make sure you follow the conditions that the sex offender program has for you, because otherwise we won't have an issue. Now, something that I do require, and I'm adding this, even though he's entered his conditions with regards to employment, you're not to have any employment as a home healthcare provider with minors. Do you understand?
Yes, ma'am. I'm already employed.
All right, thank you. But that's something that the court always orders in felony court, okay?
Yes, ma'am. And then, may I ask a question?
Yes.
For the internet stuff, I'll get with them because like for work, I do have to get online to research parts that we order and things like that. So I guess they'll discuss that.
You will need to let them know. Whatever phone you have, whatever access you have, you need to let them know that.
Yes, ma'am. I already have most of that with the police department where I'm living about.
All right. And counsel, if there's an issue with his work and his use of the computer, just come back and we'll see if we can solve that issue.
Yes, Your Honor.
All right. Is there anything else from either side?
No, Your Honor.
Nothing to defense.
All right. Thank you. Thank you, Mr. Porter, for stepping in.
You're welcome, Judge.
Okay.
Give my conditions.
Yes.
Judge, I'll hand you back the PSI.
All right. Thank you.
Oh, sorry, Judge. Thank you.
Thank you. Have a good one.
You too.
You can-
Robert, can you make sure that the clerk has the counts that need to be corrected?
It's up to you.
Oh, here's the rubber band for that. All right, attorneys, Mr. Leal, have you ever had a chance to review that question? And where is the question? All right, Norma, can you have the interpreter come back, please? And yes, if you can mute us, thank you. All right, so attorneys, with regards to the question, could Mia have dropped the charges after the outcry? I suggest two answers. One, it's either you have all the law and the evidence, or either no.
I'd say
You have not the law and evidence. The
All
first
right,
one.
and your counsel is saying something different.
Who?
Hey, no, I'm agreeing.
No,
You agree with that? You have all the law?
yes.
All right, we're going to get the interpreter back down and then we'll put this on the record. Oh. Okay. Oh, you know what? And I'm sorry, that goes with that file. All right, who's the defendant who? All right, could I have that file back? Oh, I never called it, right?
No, you haven't called us back.
Okay, all right, thank you. Who's found Kiara Kilson?
Present on that, Your Honor.
All right, Miss Kilson.
I don't believe she was present.
All right, Deputy Laura, could you make an announcement? All right, thank you. All right, court is calling 2023 CR 2666, State of Texas versus Kiara Kilson. Can I have parties announced for the record for the state
Ruben Herrera for the state.
defense?
Matthew Allen for the defense.
All right, this hearing was scheduled at 9 a.m. It is now 10:58 a.m. Deputy Mahia, did you make an announcement for Ms. Kilson? And was there any response? All right. Counsel, have you had any contact with your client?
Not recently, Your Honor.
All right. Do you know if she is on a commercial bond?
I believe so.
All right. Have you tried contacting the bondsman?
I have not.
Do you want to contact the bondsman before the court makes its ruling?
I can try to contact.
I mean, if not, well, I'll go forward with my ruling and, all right, state.
Your Honor, we'd be asking for a bond forfeiture.
All right, the bond forfeiture will be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you. Who is here on Katrina Ruiz? All right, if you'll come forward. I'm sorry, just one moment. Let me take up the matter with the court, with the interpreter. All right, could I have the parties on Juan Antonio Garcia Sanchez, please? All right, we're back on the record. In 2019 CR 6322. The interpreter is present. Could you state your name for the record?
Arlene Abrams.
All right, the court has received a question from the jurors. The question is, could Mia have dropped the charges after the outcry? Have both the state and the defense had a chance to review the question? State?
Yes, Your Honor.
Defense?
Yes, sir.
Any objections to the following answer? With reference to your inquiry, you now have before you all the testimony, exhibits, and evidence that was admitted, and you have all the law before you. Please continue your deliberations. Any objections, state?
No, Your Honor.
Defense, any objections?
No objection.
Any objections to the court sending the answer in the form of the supplemental charge back to the jury? State?
No objections.
Defense?
No objection.
All right, thank you. Hey, that happens to me all the time. Between the warranty, ARP, and Medicare, I think somebody's trying to tell me I am in the twilight of my life. Katrina Ruiz. All right, what is happening in this case, counsel?
Your Honor, say would be required, I believe all discovery has been tendered at this point. We would be asking for a reset in order to get in contact with the complaining witness on this case before an offer is tendered.
All right, Ms. Ferguson, can I have a 30-day reset on Ruiz? All right, we'll come back on June 20th. After you sign the reset form, you're excused. Thanks for dressing appropriately for court.
Yes, ma'am.
All right, have a great rest of your day.
Thank you, Judge.
You're welcome. Who's here? This is Sebastian De La Rosa.
Here, Your Honor, and he's here.
All right, if you'll come forward.
Family's here too, Judge.
All righty.
Sebastian, come on up.
And counsel, you're on this side.
Oh, thank you, Judge.
No problem. How are you doing today? Sometimes I see.
I'm putting those flowers and those sunsets just for you.
I appreciate that. I think those brighten everybody's day.
That's my intention.
All right, so is this De La Rosa is family violence? What's happening with this case?
Judge, I think the position we are in is we're not quite ready to, at least the DA isn't ready with a complete discovery or an offer yet.
All right, so
Mr. Banks is here.
all right, so do we not know if we have all the discovery yet or not?
I believe there may be a missing item of discovery on this case. And the state can, I think there may be some CPS records that are missing, we were discussing, and the state can look into that and see where those are. And
All right, so other than the CPS records, is there anything else that's missing?
not to my knowledge.
All right, Ms. Ferguson, can I have a 45-day reset on De La Rosa, please? And it's for discovery for CPS records. All right, we're going to come back on July 6th.
Okay, thank you, Judge.
All right.
And if something happens earlier, we'll let the court.
Yes. Angel Roman, Ramon? Yes. Thank you. Thank you. Do you mind staying just maybe like 10 minutes? And we'll see. And if nothing happens in 10 minutes, then we'll call you.
Okay.
All right, on Angel Ramon. This is family violence. All right, so we're here because he's supposed to find out the consequences of working in an oil field as it relates to the plea. So where are we? Because today is the plea deadline date.
Sorry, I didn't know about that last note.
Okay, yeah, because it says recall May 15th, plea deadline extended for the defendant to call, and it says consequences related to work in the oil field.
Okay.
So if you all want to sit back and discuss that, you can.
Yes, Your Honor, if I can, Your Honor.
All right, thank you.
Thank you. And, Your Honor, actually, I'm gonna check in with another court real quick and then come
Sure.
back.
Okay, thank you. Who's here on Tevin Towns?
We're present on Mr. Towns, Your Honor.
All right, if Mr. Towns can come forward.
Yes, sir. Yes, ma'am.
All right, is CPS involved in this case?
Yes, they are, Judge.
All right, do you have the CPS records or no?
Not yet. Something that we were requesting in addition to some video.
All right, so CPS records, and what is the video alleged of?
Video is of the complainant making statements, Judge, on body cam evidence that we haven't been able to.
All right, Ms. Fergus, can I have a 45-day reset on Towns for discovery? All right, we'll be back on July 6th. Just get a reset form from Ms. Ferguson, then you're excused.
Thank you very much. Your Honor. We
Thank you.
appreciate it.
You're welcome. Who's here on, oh, we just did Angel Rowland. All right, Adam Hanlon. And probation, there's no application. Court is calling 2023 CR 2675, State of Texas versus Adam Hanlon. Can I have parties announced for the record for the state?
Travis Banks in the state of Texas.
Defense,
Angela Blake.
are you Mr. Hanlon? Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hanlon, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, the state moves to proceed on the lesser included assault, bodily injury, family, class A.
Any objection?
No objection.
All right, we're off the record. So the complainant in this case, is this complainant his wife or is this the daughter? Who is this complainant in relation to him?
Girlfriend.
All right. So what I can tell you all, this is not a plea agreement I'm not going to accept. Is the complainant aware of this plea agreement?
Plaintiff is uncooperative, so we have not communicated it to her since she told us she would not cooperate in this case.
All right, so is this 111 days supposed to be a judgment satisfied?
Yes, Judge.
All right, so I'm not inclined to give him 111 days judgment satisfied on assaulting.
There are circumstances that he does have a partial defense to the case, Your Honor, but he is not pursuing it. There was the complaining witness did use a hammer on him during this incident,
Mhm.
and so he had injuries as well.
All right, I'll agree to 160 days based upon what you're telling me. I think that's more appropriate than 111 days. So if y'all want to do that, you can. If not, then it'll be set for trial. But I'm not going to give him a judgment satisfied.
We'll accept that, Your Honor.
All right, do y'all want to?
I can mean.
Right. Mr. Martinez, we're going to take your matter up right up after this.
Yes, ma'am.
Thank you. All right, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, married cohabitation? That's a Class A misdemeanor. The range of punishment is anywhere from a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you enter the plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Hanlon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea bargain agreement, the state is proceeding on the lesser included offense of assault, bodily injury, marriage, or cohabitation. They're asking that your punishment be assessed at 160 days in the Bexar County Jail. There's a $500 fine. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions? Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Your Honor, seen up to State's Exhibit 1 and its attachments.
Any objections?
Objection.
All right, state you may be excused to continue to confer. Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. The court has reviewed the same. The court will find the defendant guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just ask the court follow the plea bargain.
All right. Are you the father of the unborn child?
We don't know yet.
Oh, well, that relationship is not going well if you don't know. All right. So this is what the court is going to do. The court is going to sentence you to 160 days in the Bexar County Jail, give you credit for any time served. There's a $500 fine, time and money to run concurrent. There's an affirmative finding of family violence. There's to be no contact with Digna, D-I-G-N-A, Maria Narvaez, Nevarez Romero, outside of court proceedings. So if you're going to court to prove paternity or some other reason for going to court, then yes, but otherwise your relationship is over. Do you understand?
Yes, ma'am.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. You're going to have to make better decisions. Right? And if you cannot drink responsibly, and it causes you to have criminal cases, you should not be drinking. And there's nothing missing by drinking. You know what is a great drink? Sprite. And if you add a touch of lime to it, it's so refreshing. Coca-Cola, add some lemon to it, so refreshing. That's what I do. And Cappy's has a great drink that I've tried to duplicate and I can't. It's cranberry juice with lemonade in it. And the lemonade surrounds the cranberry, but it tastes so great. So there are other things, other drinks to enjoy other than alcohol.
I understand that.
All right, sweet tea, sometimes people put too much sugar in it, but oh well. Good luck to you, okay?
Thank you.
You're welcome. All right, Mr. Martinez, we're ready on your client. It's David Duenas, right? Duenas. One day I will get that pronunciation correct.
Hi, can you hear me?
Yes, we can. All
Okay.
right, her video is not showing. The court is calling 2023 CR 2677, State of Texas versus David Solomon Duenas. Could I have the parties announced for the record for the state?
Ruben Herrera for the state.
Defense?
Raymond Martinez.
All right. We are back because I have a violation report, and in the violation report, it's alleged that Mr. Duenas, violated the bond or protective order on December 31st, 2022. And I ask that the complainant be present, and the complainant is present by Zoom. Any objection to the complainant being present by Zoom, state?
No objection.
Defense?
No, Your Honor.
Any objections to her video not being shown? State?
No objection.
Defense? All right. Are you Miss Gonzalez?
Yes, Vanessa Gonzalez.
All right. Is there a reason why your video, we can't see you?
Let me. Yeah, my camera is just not letting me access it. I have to go back into my settings. Is it okay that my video is not showing?
Neither party has an objection. You are who you say you are, correct?
Yes, ma'am.
All right. If it turns out you are someone else pretending to be Miss Gonzalez, we're going to have a problem. You understand?
Yes, ma'am.
All right. Anyone wish to call her as a witness?
I do not judge.
Your Honor, we just have a few questions for Mr.
All right, Miss Gonzalez, can you raise your right hand for me, please?
Yes,
Do you
ma'am.
solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Vanessa Gonzalez. My legal name is Vanessa Duenas.
All right, state.
Ms. Gonzalez, I just have a few questions for you. You are the complaining witness in this case against David Duenas, is that correct?
Yes, sir.
And you did report, and you have had contact with our office in the past, right?
If I haven't had contact with the office?
Have you had contact with the district attorney's office in the past, Miss Gonzalez?
Oh, yes, just regarding this case.
And you were notified that on a previous date, the defendant's GPS was modified to partial GPS, correct?
Yes.
And you are aware that the defendant is attempting today to have his GPS further amended to tracking only, correct?
Yes.
And do you feel safe with Mr. Duenas or do you have any fears for your safety from Mr. Duenas?
Yes, I do.
What are those fears based on?
Just fear that he feels like I'm the reason for all of these issues that he's having now. And sorry, that he still blames me for everything and feels that I am the reason that he's going through all this.
And since December 31st of 2022, has Mr. Duenas been in contact with you?
No.
And would you still feel for your safety if Mr. Duenas's GPS is amended to include tracking GPS only?
I still fear for my safety.
No further questions, Your Honor.
Do you have questions? All right, Ms. Gonzalez, are you aware of what tracking is and what it means?
To my knowledge, is just them knowing everywhere where he's at.
Yes. Okay. All right. Thank you for coming in by Zoom on short notice.
Okay, yes, ma'am.
All right, so no one asked her the question, but I want to know with regards to this violation of protective order, Ms. Gonzalez,
Yes, ma'am.
with regards to violation of this protective order, how did it come that you all had contact?
He started calling my phone consistently one night. Yeah, then it was repeated calls to the point where I couldn't even enjoy time with my family.
Okay, all right, thank you.
Mhm.
So what is his current conditions?
Yes, partial judge, and he has from early in the morning till late in the evening because he works as a salesman and has long hours.
What is he doing as a salesman?
Selling cars, judge.
And is he at the actual location? Because I'm not going to allow him to do test driving.
It's just sometimes I'm one of the top salesmen in Texas, so like the other day I had to drop a car off in Midland. I asked my preacher, he told me no, so I lost out on the money because I'm just strictly commission. And I had lose out on a deal. That's how I take care of my kids at home right now. So I just it's been affecting me.
So you have children who live with you? Then why? I don't understand this relationship issue with Ms. Gonzalez. Do you understand that this relationship is over in the eyes of the court?
Yes, ma'am. I moved on.
All right, so here's the thing. She don't love you anymore. She don't want you anymore. Maybe she still loves you. I don't know. But I'm telling you, she doesn't want you anymore. It's over.
And judge, some details that we left out. I don't want to particularly talk about the facts of the case because that case is pending in the county court as well. But he has a child with her. He has a child support order with her. And the phone call was strictly about he wanting to see his child.
Well, he needs to handle that. You need to handle that through court.
He understands that now, and unfortunately, it was New Year's Eve, and it was people get nostalgic and sentimental on New Year's Eve, and that's kind of what.
Nobody wants to see anybody on New Year's Eve. The goal for New Year's Eve is to make it to New Year's Day. I can understand people being nostalgic. The only nostalgia you have about New Year's Eve is with your former partner, and she doesn't want you anymore. It's over. You understand? Is that a yes or no?
It's not understand.
So, Ms. Gonzalez,
Yes, ma'am.
the court so far allows him to have employment. And so he's saying that sometimes he may have to go to Midland to deliver a car so that he can provide for child support. My understanding is it appears, and I'm making an assumption that he has a child with you, plus he has other children. Do you have any objections to him being allowed to continue on GPS for work only?
I honestly don't trust him, and I still fear, like I'm trembling just on this Zoom call.
Well, let me ask you this. You say he called you. Did he make in-person contact with you?
No, not in person.
Because I'm not the one who handled his misdemeanor case. That's another judge, and another judge did not revoke his bond in this case. What I can tell you, Ms. Gonzalez, with regards to GPS tracking, if it's for employment only, then it's for employment only. So if he were to have to deliver a car to Midland or deliver a car somewhere else, he would have to actually provide documentation for that. He would not just be allowed to go to Midland. Do you understand?
Yes, ma'am.
So does that help allay any of your fears?
It does.
All right. So Ms. Gonzalez, if he contacts you, if he sends you flowers or a card to the child that's in your care, that's a violation. Do you understand?
Yes, ma'am.
And Mr.
Duenas.
Duenas, am I pronouncing that correctly now? All right, so I'm going to remember that. Mr. Duenas, I am serious. I'm not the person who allowed you to continue on bond after violating, talking about nostalgia. That wasn't me. That was another judge. So I'm giving you this instruction and I'm serious about bond instructions that I give people. If you contact her, we will more likely than not. If it's true, well, I'm not even going to say that. Here's the thing. If you contact her, we're going to have a hearing. And what's going to happen at that hearing is you may end up having your case heard while you are in orange. And you know what it means when you're in orange? Oh, it means that you're in custody. So we'll bring you over from jail. And then the only time you may have contact with her is if you're writing a letter from the jail. If you call her, she can always push no to receive it. Do you understand? Do you understand how serious I am about you not having contact with her? So counsel, he will be allowed to work. But if he has to travel to go to work and it's outside of that location of your job, you need to let pretrial services know. And I'll put in here that there is a permission for you to do that. You understand? All right. So you're going to be back here on July 5th then. And we'll see where we are at that point in time. Okay. All right, Ms. Gonzalez, thank you so much for coming in. And if there's an issue, call the police, let the state know and I'll get word.
Okay, thank
All right.
you.
You're welcome. Thank you.
You actually doing your order right now? Or
Yes.
Okay.
Counsel, that'll be done in a few minutes because I have to take up these other cases, but it'll be done today. All right. Denver Stewart.
Present, Your Honor.
All right. So do y'all have CPS records?
No, Your Honor, we're past that issue.
All right. So offer tendered?
No, Your Honor.
Why has an offer been tendered?
Your Honor, we have made attempts to contact the CTR, the complaining witness, between the last court date and this court date. We have been unsuccessful, but given the charge, we would like to speak with the complaining witness prior to tendering an offer, in order to have that discussion.
All right.
But to this point, we've been unsuccessful in our attempts.
All right, Ms. Ferguson, set this for jury trial.
Your Honor, my only concern is if they do contact the complaining witness and new information is revealed that requires additional discovery, will we be allowed to put it back on the discovery docket?
All right, let me just say this. This case has been on my docket since 2022. If they haven't gotten in touch with the complainant now, I highly doubt that they're going to get in touch with the complainant.
I only like to prepare for the worst. Your Honor.
All right.
That's my
Well,
only
let me help you prepare for the worst. Ms. Ferguson, set this for jury trial on May 22nd.
concern.
Yes. All right, that's the jury trial date. And it doesn't matter if it's criminal trial division or family violence. This is going to jury trial on May 22nd.
Thank you.
All right, thank you.
We do have a discovery document that we'll get to.
Yes.
Good enough.
And sign the reset form before you leave. Number, what page is stored on? Page 12. All right, thank you. Juan Carlos Torres Rivera. Who's the attorney on that?
On the reminder, Your Honor.
All right, thank you.
Good morning.
All right, if the client would come forward.
Your Honor, he's in jail, but he's not back. This
This was set on the docket, Judge.
Uh-huh.
Maybe it's not.
All right, well, let's recall it. Today is the 15th. Are we able to put this on the docket for tomorrow?
I can type Thursday, Judge.
All right, so we'll be back on the 18th.
18th, Your Honor?
Yes, thank you. Hello.
Sorry, I did forget one thing with regards to announcing on Denver Stewart.
Yes.
The court at our last hearing wanted us to notify if there was a change in his job, and there has been a change in his job, so we just wanted to notify the court.
Okay. All right, what is the change?
He lost his previous job and he has a new job here in San Antonio, Texas.
Okay.
That's all.
All right, thank you. Who's here on Angel Roman? All right, we'll just wait on that. All right, Norma, on this, send them to Judge Knox. The attorneys on the jury trial, if I could see you all, please. This is the, if you'll give one to defense counsel, that's the printout that's been given to me. That's just, if they were to ask the question, that's what would be sent back to them. And that's the issue we spoke about earlier. Norma, can you call Kelly McGinnis? Because you know Charles Blanc, I think he may still be in New Orleans. All right, and those of you who are ready, make sure you come forward because we're going to go on recess. Yes. Yes. Oh, Norma. Oh, or Nurse Ortiz. All right. All right, can you give me his number, please? Welcome back. It's like where we sing the welcome back Carter thing. Yeah. See, and you know what? The other people pretending like they're too young and they don't know, but they know because it comes on Me TV. Okay, now that song is stuck in your head, isn't it? Sure. Oh, there's Mr. Ortiz. All right, thank you. Yes, thank you so much.
Just give us a call then.
All right, thank you.
I don't know how to.
Bashan? It's, oh, hi. It seems like they may be entering into a plea. Rebecca, come forward. I haven't seen you in ages. You know, Mom always said you had a poker face. Yes. Hi. Oh. Yeah. Yeah, everything's going well. So I'm like, yeah. Yep. So now we're here. Yes. And they still haven't done anything with it. No, but you know what? I told them before I left the reason why we were moving courtrooms. So I gave them all the problems. So they know. No, I can't say they know. All right. Thank you. All right. Who's here on Javier Zepeda? All right. Thank you. I thought you had already left for your motorcycle ride. We were looking for you.
You're gonna have to give me that address again.
Okay, oh,
Louisiana.
okay, I will do that. I'll give it to you before you leave. All right, the court is calling 2018 CR 9274W State of Texas versus Javier Zepeda. Can I have parties announced for the record for the state?
Travis, thanks to the state of Texas.
Defense?
Arnulfo Ortiz.
And are you Mr. Javier Zepeda III?
Yes, Your Honor.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision,
Yes, ma'am.
and states motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Are you the same Javier Zepeda III who was placed on deferred adjudication in 2018 CR 9274W for the offense of assault family second offense on September 5th, 2018 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 5 in Bear County, Texas, the defendant Javier Zepeda III did then and there fail to report to the supervision officer in person for the months of May 2020, June 2020, and July 2020 in violation of condition number 5.
How do you plead to that? True or not true?
True. The state will waive and abandon the other allegations in the motion.
All right, any objections?
No objection.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court would find violation of condition number 5 true. Is there an agreement?
Your Honor, there's not exactly an agreement. The state is recommending that the defendant be revoked and sentenced to 5 years, but I believe defense has their own request for the court.
All right, defense, what are you requesting?
My client, his family, his employer, and I are requesting that he be allowed to do inpatient to be allowed an electronic monitoring device and to continue on probation, we would not be opposed to extending them as long as it's physically possible. And we have witnesses, we have some testimony we think the court will find relevant.
All right, probation?
Your Honor, this case expired in 2021. So an extension of probation at this time would not be an option.
Yes.
I understand, Your Honor. We have in the courtroom today, Mr. Joe Ricky Naranjo, his employer.
Mhm.
We have his mother, and we have his father. The problem here is that this man has been a heroin addict, Your Honor, and he's trying to bring that under control. Even while he had absconded, he has been going to get methadone. He's been going to the methadone clinic. And his mother's a witness to the fact that she takes him every day to the methadone clinic. And the father is here to testify that he himself has been on methadone for 10 years and is supporting his family and has a full-time job, is a supervisor, and he's a methadone user, and that's how he fights his cringes. And this young man is taking methadone.
So this is the question. Here's the thing. These are the answers I need to make an appropriate decision in this case. Now, even though I cannot extend you, I can find you guilty. I can give you regular probation, but there are questions that I have that need to be answered.
Yes, ma'am.
And those questions are going to be, where has he been? And what has he done on probation?
Tell the court what program.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record, please.
Javier Cepeda III.
All right, off the record for a moment. Could I see the attorneys on Mr. Juan Antonio Garcia Sanchez? Attorneys? Oh, if you all would come this way, please, you can come behind the rope.
You may.
Thank you. Oh, no, you can keep that.
Oh, I can keep going.
All right, so what I need you all to do is the court reporter who was here on this case, my understanding she's in the 226. If you can tell her to look for this testimony and send it to me, because the question I have from the jurors are, we are in dispute regarding the counselor's testimony. Did Mia tell the counselor about the alleged abuse after the outcry? And I don't think anyone specifically asked that question, but the court reporter may have in her notes, this is the day she spoke to the counselor, and this is the day she spoke to the outcry witness. So if you all could, if you go to the 226, because I know she's reporting in Ms. Mesa's court, the clerk will give you a copy of this. And if you will have her email me the answer, and then I will print it out for you, and we'll see if you all have any objections. All right. Norma, I need two, well, 3 copies of this. One for defense in the state and one for the court. Yes. All right, thank you. If you all will do that, if you'll meet Ms. Ferguson in the back, she'll bring a copy for you. All right, we're back on the record. So where have you been?
I've been working, ma'am, and Spain with a family member. I actually have 3 jobs.
All right, so you were in felony drug court
Yes, ma'am.
and you didn't do well. Felony drug court is a good program. And what I have is that you were sent to felony drug court. You were placed in ISF. You were returned back to felony drug court. And by the end of April 2020, you were testing positive for opiates and marijuana. You continued to use drugs. You were not in compliance with felony drug court outpatient treatment. And then you stopped reporting. And then you contacted your case manager. And I'm aware of all the parties in felony drug court because I used to be an attorney in felony drug court.
Yes, ma'am, I'm aware of that.
You contacted her in July 2020. You requested help.
Yes, ma'am.
So they arranged for you to go to detox, go to Center for Healthcare Services, and then be transitioned to lifetime residential treatment upon detox.
Yes, ma'am.
You entered detox, then you left detox.
Yes, ma'am.
Then a warrant was issued for you, and then you stopped communicating with felony drug court.
Yes, ma'am. I got scared.
Well, no,
I had a kid on the way, so I made.
don't use that fear thing with me. And let me just tell you why I don't use the fear thing with me. Because I'm reading this and felony drug court, I know how they work. When people relapse, they don't immediately cut you off.
Yes, ma'am.
And that's evidenced by the report that I'm reading, that they gave you chance after chance. They sent you to detox. So you leaving detox, don't try to use your child as an excuse. I had a baby on the way, because that wasn't the reason why you left detox. You left detox because it got hard and you wanted to use, and you're continuing to use. So do not use your child as an excuse for why you are not clean and sober.
Yes, ma'am.
So I don't believe there's anything that I can do for you, because felony drug court has tried it all. You absconded from felony drug court and they still accepted you back after you absconded. They were giving you help, and then you absconded again. And I understand that there comes a point in time in people's lives where they're like, okay, now I'm ready to do it. But at some point in time, the court can't continue working with people who don't want to be worked with. And your problem is your chances to be worked with have elapsed. There is no chance to be worked with. You're going to have to do it on your own.
When he wasn't reporting, he was taking methadone to make sure he did not go down the spiral. He was trying, and his family's here to say that they worked with him with that.
But all he had to do was pick up the phone and call felony drug court. Have you read? I'm going to read this to you. You've been an absconder for almost 3 years. As an amended condition of probation due to a motion to revoke, Mr. Zepeda was placed in the felony drug court program on January 24th, 2019. That was me who did it. It says, Mr. Zepeda struggled to anchor in with outpatient treatment and admitted a drug relapse. And I can tell you, when I placed you there in 2019, I had to call them and say, please accept him. I know y'all are booked and don't have room for him, but he's on the edge. Can you please accept him? And they did. And then it says, as a graduated sanction, they placed you in the Bexar County ISF program on October 30th, 2019, and you completed it on March 3rd, 2020. You returned to the felony drug program, and by the end of April 2020, you were testing positive for opiates and marijuana. Mr. Zepeda steadily declined into further drug use and non-compliance with the felony drug court program rules and outpatient treatment. Mr. Zepeda fell off the grid and stopped reporting for the months of May and June of 2020. Mr. Zepeda contacted his felony drug court case manager in July 2020 and requested help to regain sobriety. She arranged for you. They didn't say, oh, we're going to revoke you. We're going to send you back to the 187. She said, we're going to get you into detox. So they sent you to the Center for Healthcare Services. And then they said, after that, after detox, you're going to go into lifetime residential treatment. And you entered detox on January 7th, 2020. You stayed there for 2 days. They said a couple of days. In my mind, that means 2. And you left. A judge's warrant was issued for you on July 13th, which tells me when you left on July 7th, they still gave you chances to get back in line. And then it says you stopped communicating with all felony drug court team members and you remained a fugitive. And what I can tell you, in felony drug court, there are attorneys there who always say, let's try to get them back in compliance. Let's try to find them. They have officers who are trying to get you back in compliance, caseworkers, the counselors, everybody's probably on your phone calling you, calling your family. And you just left. I can't do anything for you. You're going to have to get the treatment on your own. I'm going to find you guilty. The only issue is how much time. The state is asking for 5 defense. What are you requesting?
3 would be fair.
Okay. All right, this is what the court is going to do. The court is going to find you guilty. The court is going to sentence you to 3 years in the prison. Give you credit for any time served. I'm going to ask for the therapeutic community. Therapeutic community does not increase your time in custody, but if you're serious about getting clean and sober, you need to request that. I can't order it. There's a $500 fine, time and money to run concurrent. There's an affirmative finding of family violence. There's to be no contact with Carla Chavez.
Yes, ma'am.
All right, and state, will you let Ms. Chavez know that he's been revoked and he's going to prison?
Yes, ma'am.
All right. Just show you what's entitled trial court. You probably want to go around. Okay. To show you what's entitled trial court certification of defendants' rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, this is not a plea bargain agreement. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand?
Yes, ma'am.
All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
And also because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. If you have a child, you need to do better. You have family here who's supporting you, you need to do better.
Yes, ma'am.
You need to pick up the phone because I know felony drug court gave you the tools you need in order to stay clean and sober. It's just a matter of you using them. All right?
Yes, ma'am.
All right, good luck to you.
Thank you, Your Honor.
You're welcome. Who's here on Kenan Brown? Hello. Oh, can you give that to Mr. Ortiz?
Thank you.
You're welcome.
To give you an update on this one, this was the
Yes.
one that was in federal custody. I do have new information that he is done with whatever he has to do federally,
Mhm.
but he would not be able to be transported here today.
Okay.
But my clerk said that a June setting should be available.
All right, Ms. Ferguson, can you give me a June date on Mr. Brown? And is it best later June, the week maybe of June
My
19th?
understanding was like June 20th, somewhere in there. Okay, I don't know if
All
that's
right.
the right date or-
Norma, can we set this the week of June 19th? All right, so we'll come back on June 22nd.
Thank you, Judge.
Thank you.
I think so. This is one that we touched base on several times over the past couple of months. Yeah. My clerk said that they were supposed to be sent.
All right, we will see you back then.
Thank you, Judge.
Thank you. All right, the next person up is going to be Kevin Young. All right. Hello, Mr. Young. All right, so on this case, so discovery, review, and an offer is due. Where are we?
Yes, Judge, I mean, this guy actually came in this last Friday and reviewed the case file that we had. There's some items that may or may not be missing. That I did supply 2 reports to her today that she said she didn't have in her possession. And she was asking for one additional thing about the detective file, which I don't have access to. So we're just trying to get past a little bit more discovery on this case, Your Honor.
All right, we'll call it back on June 22nd.
Okay, Judge.
All right, and next time, I mean, I appreciate the way you're dressed. Do you have nothing other than a t-shirt?
I'll buy me some slacks and a shirt for you.
I'm sorry, what?
I'll buy me some slacks and a shirt next time I come.
Okay, all right, awesome. Thank you. Thank you very much. I appreciate that. Summer Muniz. Yes. And Deputy Laura, we're gonna take our break at 12:30. And the only one we may have coming back is Mr. Gunner. All right, probation, this is an application for deferred. Court is calling 2023 CR 2906, State of Texas versus Summer Muniz. Can I have the parties announced for the record for the state?
Lindsay Shaw for the state.
Defense?
Suzanne Kramer for Miss Muniz.
Are you Ms. Muniz? Counsel, you received all the discovery. Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Muniz, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, ma'am.
Ms. Muniz, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with tampering with the government record or license or seal? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Yes, ma'am.
Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights? No problem.
I'm sorry.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Muniz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Oh, no, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. They will take in consideration 2023 CR 2907. County Court cause numbers 667-964, 685-144, and 700047. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
Yes, ma'am.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
There's not.
Next, I'm showing you outside the plea bargain agreement. There is a request that your deferred adjudication be for a term of 4 years. There'll be a TAP evaluation and 150 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
The state offers states exhibit 1 and all the time. No objection.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. State, you can continue to confer.
Thank you.
All right, reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Is there anything you would like to say on behalf of your client?
Judge, at this point, my client wishes to waive the PSI and do the TAP eval as a part of her deferred adjudication probation. And then go ahead and go along with the rest of the plea bargain agreement.
All right, is there anything you wish to say?
No.
All right, do you have any children?
Yes, ma'am.
What are their ages and how many do you have?
I have one, she's gonna be 7. On Wednesday.
And where is she now?
She's with my brother-in-law.
All right, so you don't have custody of her.
I do have custody, but she's just staying in for now.
All right, if you drug tested today, what are the results going to be? And before you answer, note that you will give me a drug test today.
Okay.
So what are the results going to be?
Real quick, come on, Daddy.
Dirty for what?
We,
And what else?
that's it.
All right, well, we're going to check on that. Can I get a UA? And we'll come back. And so that will be done today. So do you still wish to stick with just weed?
Yeah.
Okay, all right, we'll come back. All right, could I see the parties on the jury trial matter? And can you bring down an interpreter, Norman? Okay, awesome. No, I'm not talking about yours. I'm sorry. Where is Raphael Leal?
I believe Mr. Leal and Mr. Kimbrough are still down in the 226 talking to the court for to get the statements wrong.
Oh, they've already.
Oh, you already did it.
Yes.
Then I'm not sure where they're at.
Okay, can you call Brian Kimbrough, Mr. Leal? And state, this is what the court reporter has sent me. And if you'll give one to the defense. Who's here on Albino Acuna? All right. Who's here on Leah Thompson? All right, today, this case is set for a plea deadline.
I have talked to the prosecutor. There's a couple of documents that we have to turn over and might phase a plea offer on it. We're gonna ask for 2 weeks plea deadline reset.
All right, so what items are being turned over?
Judge, from my understanding, from what defense counsel was telling me, there were several classes that the defendant has taken where she has certificates. And I just wanted to see those before I made a decision.
All right, Ms. Fergus, can I get a 2-week reset on Leah Thompson? All right, we'll come back on June 5th. Ms. Ferguson will give you a reset form.
Thank you, Judge.
Thank you. Who's here on David? Oh, shucks, that's not the one. Angel Roman?
Your Honor.
Yes,
I missed you twice, Your Honor. I apologize.
that's okay.
So we were supposed to give an update as
Yes.
far as, we do have his work schedule, Your Honor. And
So the issue was whether or not being on probation would interfere with his work schedule. That's my understanding.
yes, from what I understand, I don't believe it will, however, it's the.
Because I work in oil fields by Midland, Texas, and it's 2 weeks on, 2 weeks off. I already confirmed with my rig manager that I'll be checking with probation as well. He has no problem with that.
Okay.
But it's just, as far as the classes, is it okay if I take them when I come back?
No, probation does, I believe, have online classes, or either you can do classes when you come back.
Okay. So I believe we have an answer.
All right, so are we doing a plea today?
Yeah, no, I'll be fine.
You would like to take a plea today.
All right, if y'all would do the paperwork.
Get it done, Your Honor.
All right, thank you.
Thank you, Your Honor. Sorry for the.
No
I
problem.
didn't get you an answer.
All right, to attorneys on our current jury trial case, did you all review the court reporter's response?
We did, Your Honor. I think, at least from the state's position, something that may be lacking from this draft transcript is it does mention the time she visited the counselor after the outcry, but I believe we did put on the record when she visited the counselor before the outcry, and I think they may try to see if we can get that included. In the transcript.
Well, see, the question is, did Mia tell the counselor about the alleged abuse after the outcry? So what you need is, for them, it would seem to the court, and if I'm wrong, tell me, it would seem to the court, what you need is when she told the counselor.
Well, we have the transcript, and according to the transcript, it says on the 24th, she was asked, when you met with Mia, without saying anything, what you said, did she say anything to you that you would consider to have been reportable? And she said, she stated that she had a conversation with her mother. And then she said, her mother became aware that Mia had been abused physically and sexually. So if she's referring to what she told her mother, you had ruled that what she told her mother, because she was not an outcry witness, what she told her mother would not be the abuse.
No, so the outcry person is the officer who came.
Right, and
So-
that's not part of their confusion. Their confusion is when the counseling visits occurred with regard to when that outcry was made. I think they're wanting to know, did she make that outcry on her first visit, or was it a subsequent?
No.
visit?
The question is, did Mia tell the counselor about the alleged abuse after the outcry? The outcry is the officer. So this question is, did Mia tell the counselor about the alleged abuse after the outcry to the officer?
And I would say the answer is no, based on the testimony, because what she said in the testimony was that she learned what she had told her mother, which was not an outcry.
No. We're not on the record yet because we don't have the interpreter. Well, the interpreter is here, but this is what needs to be taken from the court reporter. What needs to be taken from the court reporter is there anything in there that says that Mia told the counselor about the alleged abuse after the outcry. And the outcry would be the outcry to the officer. Are you saying that is not correct, State?
Well, so what I'm saying, they seem to be saying that this mention here, because she's mentioning what she told her mother, doesn't count as after. My point is, she is mentioning the alleged abuse to the counselor, even if she's only mentioning, well, I talked about it with my mother, or I made my mother aware. They're still talking about the abuse after the outcry, which was September 23rd. This is September 24th.
But remember what she told her mother initially about being touched. We had a big hearing about that. And what she told her mother, because it was not the outcry.
All right, we're gonna go on the record. All right, court is calling 2019 CR 6322. If I can have interpreter and your client come forward, please. State of Texas versus Juan Antonio Garcia Sanchez. Hi. All right, thank you. Could you raise your right hand for me? Do you solemnly swear or affirm the test, I'm sorry, that you will faithfully translate from English into Spanish and Spanish into English, so help you God? All right, if you can lower your hand and state your name for the record. All right, the court has received a question from the juror. This is the question. We are in dispute regarding the counselor's testimony. Did Mia tell the counselor about the alleged abuse after the outcry? Have both parties had a chance to review the question? State.
Yes, Your Honor.
Defense.
Yes, Your Honor.
Off the record, there was a discussion with the attorneys, and it appears that each side has a different definition of what outcry means. For the state, how are you interpreting this question?
Well, Your Honor, the state doesn't have a different definition of what outcry means. The state's position is that they're asking, did she talk about the abuse after the outcry? The question was not, did she talk about the outcry after the outcry? And defense seems to be saying, well, since she's only talking about what she said to her mom, then she's not talking about the outcry. But the question was, did she talk about the abuse? And yes, she did. She went in on the 24th and she told the counselor about what she talked about with her mother, which was the abuse. She didn't talk about the officer specifically, but that's not what the jury asked. The jury just asked, did she talk about the abuse after the outcry? The testimony clearly shows that she did talk about that.
And so when we speak of outcry, are we talking about the outcry? I understand the state's point, but when we speak about outcry, are we talking about the outcry that was given to the legal outcry witness?
Well, I think no matter how you look at it, if you're looking at the outcry to the legal outcry witness, I mean, that's just a moment in time. The outcry to the legal outcry witness, that happened at a moment in time, and the jury's asking, after that moment in time with the counselor, did she talk about the abuse? And I think the answer is yes, she did. And the record shows that she did. I think defense is trying to say, well, she didn't talk about the outcry about her statement to the officer. So we can't consider that as talking
Well,
about
here's
it.
the answer to this question is either yes or no. That's the answer to this question.
Well, I think, Your Honor, I think the answer is yes, but to the extent that there is a dispute about the testimony, and we've informed the jurors that when they have a dispute and they tell us that they have a dispute, that they would then could be provided the record that's.
But the question that the jurors are asking, they are not asking for the context of the abuse. They're just asking, did she tell the counselor about the alleged abuse after the outcry? That's either yes or no. That's not, oh, let me give you everything that she said. The answer is either yes or no.
Right, but it's in the context of they have a dispute about the testimony and they are asking for clarification of what that testimony was, not just to.
They're not asking for clarification. It's sort of if someone were to say, we have a dispute. Did it rain or did it not rain? You know, did a witness testify that it rained or not rained? The answer to that is either yes or no. And the problem with it is when they say outcry, I don't think either side know if they mean the legal outcry witness, which the court determined was the officer, or if they mean the mom. Now, what I can tell you from reading the court reporter's record, with which both of you all have, the answer to their question seems to be yes. Is anyone saying the answer to the question is not yes?
Yes, I am.
All right, so go ahead.
Okay, so what the counselor says is, she stated, in the answer to the question, did she make a reportable? Did she say something? She stated she had a conversation with her mother. And then she said, her mother became aware that Mia had been abused physically and sexually. And Mia wanted me. Now, the mother, what was said, the conversation with the mother, okay, which technically took place before.
Yes, go ahead.
Technically took place before she talked to the police officer. Okay, and so she had and based on this, she had a conversation with her mother. If she's reporting to the counselor, the nature of the conversation with the mother.
Right, I'm sorry, just 1 second. Ms. Ferguson, see which one is quickest for them, if it's Candy's. Deputy Laura? What is quicker for lunch for them? All right, so let's do that. All right, we're back on the record.
And so based on this, it was based on her conversation with her mother. She stated she had a conversation with her mother. Now, we had a hearing about, and that was before she spoke to the police officers. And so we had a hearing on this, and the court determined that what she told her mother did not make her mother the outcry witness. It made the police officer the outcry witness. So if what he communicated to the counselor was a conversation she had with her mother, then I would say that was not what's the question?
So
that was not about the alleged abuse after the outcry. But I would say this, Judge, here's what I would say. If the court feels that it has to be put for the jury, I would say probably the transcript, to read that portion would be better than saying yes or no, because I think there is a dispute as to exactly what was communicated to the counselor. If it was communicated to the counselor was what was said to the mother, and since you already ruled that what was said to the mother was not enough to describe an offense that would be.
But here's the thing,
Then
I understand both parties' point, and I understand that sometimes, because I've been in both your positions before, everybody wants to make the answer to fit how they want it to be for whatever the jury may decide. But I'm telling you both, when I read this, I was going to put this up something. But you know what? You can go ahead and do that for me. Sure. Yeah. And then I'll do everything tomorrow. What I am reading, and it's a simple question. If you take all of the legalese that we attorneys like to use, it's a yes or no question. Did Mia tell the counselor about the alleged abuse after the outcry? The only issue is, what do they mean by outcry? Now, if they're saying for them, outcry means anybody she told, okay. If for them, outcry is the legal outcry, because you all are trying to put your legalese on what outcry means. We don't know what outcry means to them. We don't know if this means, did she tell the counselor about the alleged abuse after whoever she told it to beforehand? We're assuming that outcry means You're assuming it means the legal outcry. They're assuming it just means her mother.
Your Honor, the state's position is that the answer is the same, no matter which you apply. She talked about the council, both outcries happened, alleged outcries happened on the 23rd at about the same time. The question is, after that happened, did she talk about the abuse, not the outcry, the abuse with her counselors? On the 24th, she did, and that was after, whether you say the mother's was the outcry or the officer. The statement to the counselor, which was about the abuse, happened after that time. So it doesn't matter which one you're looking at.
Well,
The
here's,
answer is yes.
where is the court reporter's record?
Oh, I have that here.
No, I have the court reporter's record. I mean, where is it in the record about the officer?
No, it doesn't say about the officer, but I think.
Because I mean, this
I
just
think-
says
I
the
think
mother.
My issue is not so much with the officer, but it's about the alleged abuse. Because what she told her mother in that initial conversation was not the alleged abuse. Because she's actually not charged with offensive touching, indecency, anything like that. And her mother initially was saying that it was something about touching and offensive touching, and then you felt that, you know, you ruled that that was not an outcry. And so, and then the court.
So the issue again is, what do they mean by outcry? This is what I want you both to do for me. I want you to both go back to the court reporter and see if the court has any information with regards to the legal outcry person in this question. Did anybody ask her about that?
I don't recall that it was asked, but Your Honor, the state is submitting that it really doesn't matter which one.
It matters to the court. So you all need to go back down to the court reporter and find out if she has any thing in the record about the legal outcry, and see if they said if there's any information in the record that the legal outcry witness, if Mia told the counselor about the alleged abuse after the legal outcry witness. Let's see what the court reporter has on that, and then the court will make a decision.
Okay.
Because I want it to be fair, and I want it to be the correct ruling. So if you all will ask the court reporter if she has that information, if she does, tell her to email it to me and I will give you all copies. Okay?
Okay, thank you.
All right, thank you. All right, Munoz. All right, we're back on the record in 2023 CR 2906, State of Texas versus Summer Munoz. All right, so what did you test positive for? And you want to go back to I only use marijuana with me?
No. I counted for meth, marijuana, and.
I'm sorry. Can you speak up and could you uncross your arms? You're not a little girl. We're not in the classroom. You are in a felony court
Yes, ma'am.
where you could potentially go to prison. So what are you been using?
Meth and marijuana.
When's the last time you used meth?
Maybe like 2 days ago.
No, it's more than 2 days ago. How often are you using?
I just got out of jail, so I haven't been using that often.
Well, I mean, you went straight from jail to use meth. Don't give me attitude.
I'm not.
You've been dishonest with the court. You made them waste of, you think UAs just are free? You made them waste a UA, telling me that you're going to be positive for marijuana only when I knew it was not going to be the case. And now you're positive for meth, amphetamines, and marijuana. So who are you using with? Are you using by yourself in a dark room? Or are you using with some boyfriend? Who are you using with?
No, actually where I'm staying at.
And where is that?
With a friend.
Who is this friend?
Her name is Natasha.
All right. I like the way you make up names. I can't believe anything you're telling me now because you were dishonest about the drug use.
It's the only place I have to stay at right now, so they use, and it was tempting.
All right, so, I'm gonna want a TAP evaluation ASAP, please. Are you employed?
No,
So how are you supporting yourself?
I'm not,
So who's supporting you?
nobody.
Well, what are you eating other than drugs?
I have food stamps.
I'm sorry, what?
I have food stamps.
Who's giving you food stamps? You don't have your child with you. Those food stamps are for your child.
Yes, ma'am. I just recently applied and I got approved for emergency food stamps.
I cannot understand a word
I
you're saying.
just applied and I got approved for emergency food stamps.
I know people who really should have food stamps that don't get approved. So you don't have your child with you. You're using meth. You're probably selling your food stamps for meth. And this is a tampering with a government record. So I don't even know if you obtain your food stamps legitimately. So what did you tell them in order to get food stamps? Because you don't qualify. I think she's probably going to end up with another criminal case.
Yes.
Because I don't know of the government giving out food stamps to people who won't work. There's nothing wrong with you. You don't have your child with you. Somebody else is taking care of your child. Oh, no, not for me. Thank you.
I have to look for work. It's like one of the conditions that they gave me in order to get food stamps. So I'm supposed to be going to the workforce.
Well, you're obviously doing a poor job of it, but I tell you what, you're in this court, you're going to have employment. I'm not going to, the length of probation is outside the agreement. So it's going to be more than 4 years in this court because she has a lot of work that needs to be done to, I don't know why you're giving me the attitude.
No, I'm not trying to. I'm sorry.
Yes, you are. Either that or it's because you're high. I don't know which one it is, but you're giving me attitude, and that attitude will most likely be readjusted by me at the Bexar County Jail. So I don't know if your attorney told you this, but I can send you to the Bexar County Jail as a condition of this probation, and I can also send you to the state jail facility as a condition of this probation for attitude readjustment. Do you want that?
No.
All right, so I'm going to sentence her to 6 years deferred adjudication. You're getting a job, and there are plenty of jobs that are available. You're going to knock your pride aside, and if you're going to be flipping burgers at McDonald's or working on fries, you're going to be the best fry person you can be until you move up. You understand?
Yes, ma'am.
How far did you go in school?
9th grade.
9th grade. Why did you drop out?
I have a problem at home.
What were these problems? You using drugs?
No, not necessarily. Just like things that were going on with my mom's marriage and everything else.
Mhm. And what's that tattoo on your neck?
And it says only the strong survive.
All right. People love to put down sands on their bodies because they can't remember them. All right, it's going to be a $1,500 fine probated. Proof of employment. And it's going to be proof of full-time employment within 15 days. If you have to get 2 part-time jobs, you will get 2 part-time jobs for the court. Full-time employment is at least 40 hours a week. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. Has Child Protective Services been in your life?
Yes.
And so were your rights terminated?
No,
What happened to your parental rights?
I still have my rights, but I just don't have my daughter. My family just agreed to take care of me until take care of my daughter until I get back on my feet.
Parenting classes, and I want intensive parenting classes. There's to be 150 hours of community service restitution that will not be waived. She has to do those. You're either going to get your GED or either you're going to get some sort of trade certificate. Take in consideration 2023 CR 2907, County Court Cause number 667-964, 685-144, 70047. I'm going to want a referral to felony drug court, TAP evaluation. If she's not accepted in felony drug court, we'll start with intensive outpatient treatment with probation. There's to be regular reporting by Zoom or in person. the UA hotline, and she used to be tested once a week. Make sure the levels are going down. If the levels start going up, issue a motion to revoke. And I'm going to want field visits 1 time per week until further notice. Probation, is there anything else she needs? Oh, I'm sorry, 1 time per month. Probation would have got a shock.
That'll be all.
Anything else you need from the court to be successful? Showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
We can go off the record. So that tattoo you have about only the strong will survive, that's the mode that your child is being in. And your child should not be in that. Her parents should not be using drugs. Her parents should get her life together, and somebody else should not be raising your child. And you just 100% living off the government, that's not going to happen in this court. You get another job. Do you understand?
Yes, ma'am.
And if you got those food stamps illegally, you better turn them in, because your counsel can tell you what the government does. They wait till your food stamps, when you take those monies from the government and you shouldn't have it, they wait till it becomes a felony. Then they turn it in. Do you understand?
Yes, ma'am.
All right, thank you.
Thank you, Judge.
Yes.
I brought the court reporter here so you could explain exactly what you're.
Sure. All right.
You put, just right here.
Okay, hi. So what we're looking for, because I don't know if this jury knows outcry or legal outcry. In regards to the question that was sent to you, can you see if there's anything from the officer relating to, what was the officer's name? Feliciano. Can you see if there's anything related to him about the outcry?
Sure.
All right, before the counselor.
In the counselor's test.
Yes.
Oh, in the council.
Yeah.
Yes.
Right.
All right. And yes.
Thank you. That's just all I was gonna ask.
All right, who else here needs the interpreter?
I do, Judge.
All right, and what's your client's name?
Albino Acuna. You want me to bring him up?
Albino Acuna? Yes.
He's coming.
Norma? Norma. So guys, we're sending the jurors lunch.
Oh, good.
Yeah, okay. Okay. And can you make sure that it's 14 that's already for the 2 people out there?
Yes.
Okay, all right, thanks. Oh, you know what? Have you already sent it in?
No, I wanted that. Okay.
Yes. Yes. Acuérdate que va a estar en español. Español, inglés.
All right, so where are we on this case?
Your Honor, I'm here appearing for Ms. Legarreta on this matter. She wants to know if we can send this to felony impact court for trial.
No, I mean, do you all have all the discovery?
I believe that she should have it. I couldn't tell you. She just.
All right, is she appointed on this case?
I believe she is, Your Honor.
All right, she needs to be here. I mean, we can't, with appointed attorneys, you're not allowed to do, oh, I'm having somebody else fill in, or this is an associate. Are you an associate with her?
We second chair a lot of each other's cases.
All right, so she needs to be here to make sure her client understands. And is he a citizen?
Yes,
Yes.
Okay.
I don't need this. I know English.
Oh.
You don't need to speak.
So see,
Yeah, I'm sure San Antonio born and raised.
thank you.
No, I think that's me.
But you know what? It's always nice for everyone to practice.
Yes, ma'am. Yes, ma'am.
Even though she doesn't need to practice.
Yes, ma'am. I respect.
She speaks French beautifully.
We.
Oui, thank you. All right, so he doesn't need an interpreter, and I'm gonna write on the file, no interpreter needed. So we're gonna recall this. Where's Miss Legarreta?
She's not here at the moment, Your Honor. I don't know exactly where she's at. If she's like in another county, I don't know. I can ask her.
All right, so we're gonna recall this for tomorrow. She needs to be here.
Okay.
All right, so Norma, Mr. Acuna, recall tomorrow. Because has she even received an offer from the state?
We have not received an offer.
And people are saying they're ready to trial. So if he were offered a Class C misdemeanor, which I've seen it happen before in an aggravated assault, y'all still want your jury trial?
No.
See, that's what I mean. So I don't know if she has discovery. I mean, do y'all have all the discovery?
I can ask.
And she's like, she wants a jury trial?
No, it was my brother-in-law, my daughter.
Okay. Yeah, no, I'm not asking you about the case. That's why your attorney needs to be here.
Yes, ma'am.
All right, so we're gonna bring you back.
Sorry.
Oh, no problem. We're gonna bring you back here tomorrow. But I tell you what,
We printed many.
I tell you what, you're wearing that Patriots shirt. I don't know if the Cowboys or Houston fans are happy with that.
Good.
All right, Ms. Ferguson is gonna give you a reset.
Yes,
And you
ma'am.
need to be here tomorrow
Yes, ma'am.
at 9 a.m. Ms. Ferguson, can you give him a reset? All right, thank you. Thank you so much.
See you tomorrow.
Okay. Christopher Trinidad.
Yeah, excuse, or
Yes.
are we still with the question?
Oh, we're waiting for her to look that up.
All right, wait, call again?
Yes.
Thank you.
Who's here on Christopher Trinidad? Christopher Trinidad.
Yeah, I believe it's Miscellaneous case.
Okay. Who is here on Jeremy Thomas? Jeremy Thomas. Mr. Thomas, just stay seated. We're waiting for your attorney. Travis Murphy.
Present, Judge.
All right, Mr. Murphy,
He's in custody, Judge.
come on down. All right, what is happening in this case?
I'm still reviewing discovery, Judge, to make sure the state has everything. I'm not entirely sure they've turned over everything. The discovery indicates that there was at least one shell casing recovered, and I have yet to find anything that indicates whether that was analyzed or will be or has been.
All right, we're going to recall this for June 15th for discovery. Caroline, could you put this one for June 15th? Because Travis Murphy. All right, if you sign that, oh, we don't need you to sign it. He's in custody.
Yes, ma'am.
All right, hello.
He'll be here.
So we'll be back on June 15th.
Thank you, Judge.
Thank you. John Dominguez. Who's here on John Dominguez? Thank you. All right, on John Dominguez, this is plea deadline date.
I made a counteroffer to the state, but they're in trial and we're not able to confirm currently, so
All right,
can we have like a week or something to?
okay. Let me look at this. All right, we're gonna bring you back on the 22nd.
1 week from today.
Yes.
That's perfect.
Caroline, on John Dominguez, he's gonna come back, Norma, on John Dominguez, we're gonna bring him back on May 22nd for disposition.
And he goes sit back down?
Yes.
Okay, thank you.
All right, and it's John Dominguez, May 22nd for disposition. Christopher Trinidad? Nope. Roger Salcedo? All right, what is happening with Roger Salcedo?
Your Honor, we provided some information to the state regarding some potential exculpatory information of one of the investigators who's involved in the case, named that had a discussion with my client after the fact. So they're gonna look into that and then go from there.
All right, how much time do you need, State?
Judge, so I sent in a request to try and see if I could trial with the person on the card. I asked my victim advocate to set it on Friday, but depending on what we're doing on Friday, we're gonna be in trial.
You want to set it for next week?
if we could get just a little more time, I'm just.
2 weeks?
Yes, ma'am.
All right, Ms. Ferguson, can you set this the week of May 29th, please? June 1st?
Yes, Judge.
All right, Ms. Ferguson, if you can give them a reset date for June 1st, and that will be your final plea deadline date.
Thank you, Your Honor.
You're welcome.
My findings, please.
After he signs the reset form.
Yeah.
Yes.
Thanks.
Roger Salcedo. Moses Maldonado.
Present, ready,
Thank you.
Hello,
Hi,
how are you doing?
great. You've been very patient.
No problem at all.
It's a hectic Monday.
It seems like not just your court. Well,
Well, you know, you have to multitask. Probation, this is no application. Court is calling 2023 CR 2970, State of Texas versus Moses Maldonado. Mr. Bonk, could you move your person down to that end? All right, could I have parties announced for the record for the state?
Chop the state.
Defense,
no offense for Mr. Maldonado.
are you Mr. Maldonado?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
We have.
Court will find that the state is in compliance with discovery. Mr. Maldonado, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Waiving habitual.
Any objection?
No, we have no objection. We're very grateful.
Mr. Maldonado, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with felony in possession of a weapon? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you enter a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Judge.
Do you believe he's currently competent, was legally sane at the time of the offense?
Yes, Judge.
Mr. Maldonado, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, I did.
According to the plea, punishment is to be assessed at 6 years in the prison. There are no applications. The state will take in consideration 2023 CR 2969. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Very much so.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions? Outside the agreement, you're requesting that this case run concurrent with 2018 CR 9258W. Did you understand that those are recommendations from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
State Office State Exhibit 1 and law attachments.
We review them and have no objections, Your Honor.
Mr. Maldonado, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and judgments, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. And the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
All right. So the only issue I have a question about, what is the issue with the running concurrent?
So he is on parole. He has a blue warrant pending currently. Obviously, we understand that parole ultimately is the one that gets to decide that, but it certainly would help if the court would notate on the judgment that it will run concurrent if he gets revoked on his revocation.
All right. Anything you wish to say, Mr. Maldonado?
Oh, man.
All right. The court will follow your agreement. The court is finding you guilty. The court will sentence you to 6 years in the prison, give you credit for any time served. Court will take in consideration 2023 CR 2969. This will run concurrent with 2018 CR 9258W. Do you understand that the court has no jurisdiction to order the parole board to run these cases concurrently?
Yes, ma'am.
And do you understand that that is merely a recommendation from this court?
Yes, ma'am.
All right. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Very much so.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. How old are you?
40.
You are getting close to the point in my life that I'm in, which is I'm in the twilight of my life, or as they say, the winter of my life. So you're going to have to ask yourself, do you want to continue in and out of prison, in and out of jail, breaking up and finding the majority of your life is in custody or not? You know, these are the choices you have.
Yeah.
Now, the other question I have for you, did those tattoos hurt, the facial tattoos?
Some won't be.
What's the most painful?
The one in the middle of my forehead.
All right. And so you wanted to give it to me with the finger. Okay.
No.
All right.
Judge, and just for the record, well, we're off the record, but I've known Moses. I've represented him off and on for many years now. And it's always so disappointing when I hear that he's been arrested again. I've always liked Moses. He's very intelligent. He's got a great sense of humor. Unfortunately, he struggled with addiction like so many people. And I'm hoping that at this point, he'll seek some treatment in the prison. And certainly when he gets out, we'll try to maintain that path.
Try.
All right. You're going to have to do it. Good luck to you.
All right. Good luck to you.
All right. Bye-bye. Have a good one. All right. Juan Morales. Thank you.
Hang out in case you had another question before I went to lunch.
Oh, no. Go ahead and go to lunch. Let me print this email.
That was me.
All right. Just 1 second. All right. So I'm printing that out and I'll let you all review it. All right. So what is happening with Juan Morales?
Judge, it's first setting. I'm still going through the discovery to see if the state has complied. And some asking for another reset.
All right. Ms. Fergus, can I have a 30-day reset on Juan Morales, please? Okay. Oh, let me look at the calendar here.
We can do like you did my other client, June 15th. I think that
Okay.
worked.
All right. Caroline, on Juan Morales, he's going to come back on June 15th. All right. Thank you.
Thank you, Judge. Thank you.
All right, counsel, if you'll pass one to the state. James Earl Bradley. And then your guys here, right? All right. All right. Hello, Mr. Bradley. How are you doing today?
Pretty good. How about yourself?
Oh, I'm doing great. How's life treating you?
Doing pretty good. Can't complain.
Okay. All right. So where are we in this case?
Judge, I hadn't seen him in a long time. I just saw him today. I was gonna ask the court for 30-day reset so I can go over everything.
All right, Mr. Bradley, are you staying in contact with your attorney?
Yes, ma'am.
All right, do you have all of his information now?
Yes, ma'am.
Do you have a phone and everything so you can contact him?
Yes, ma'am.
And he has your phone information.
Yes, ma'am.
All right, so what we're gonna do is I'm gonna bring you all back on June 15th. And we'll put it down as discovery. Ms.
Thank-
Ferguson, on James Bradley? If we're gonna recall him back on June 15th. All right, thank you. So after you sign that, we'll come back. So that'll be for discovery for your attorney to make sure he has everything, okay?
Yes, ma'am.
All right, thank you.
Thank you, Judge. Can I excuse after this?
Yes. All right, could I see the parties in the back on Mr. Garcia Sanchez? All right. Thank you. I have a ginormous stack over here. Pedro Alonso. All righty. Javier Esparza.
Your Honor, we're present, right?
All right, counsel, where are we on this case?
Yes, Your Honor, this is the first setting after the case was indicted at the end of March. I reviewed the state's file and it is still missing one of the DNA forensic testings. So we'd like a reset for those results.
All right, Ms. Ferguson, can I have a 45-day reset on Javier Esparza, please? All right, we'll come back on July 6th to see where we are.
All right, thank you, Judge. May my client be excused after he signs?
Yes.
Thank you. That is.
Who's here on Angel Roman? Roman, you'll come forward. And we may have to stop in the middle because the interpreter may be down. All right, probation, this is for deferred adjudication. Court is calling 2023 CR 1476, State of Texas versus Angel Roman. Can I have the parties announced for the record for the state?
Thanks to the state of Texas.
Javier Garcia for Angel Ramon and I'm Mr. Shannon Love's associate attorney here.
All right, are you Mr. Angel Roman?
Yes.
Any objections to this attorney standing in? All right, counsel, you received all the discovery and did you review it with your client?
Yes, Your Honor.
Mr. Roman, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes.
Court will find that the state is in compliance with discovery. Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented?
No, Your Honor, the state is making a motion to proceed on the lesser included assault family class A misdemeanor.
Any objection?
No, Your Honor.
Showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, family, married household as a class A misdemeanor? Range of punishment is anywhere from a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine.
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Roman, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of assault, bodily injury, family, or household. They're recommending deferred adjudication. There's an affirmative finding of family violence in the BIPP course. Did you understand with the affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the plea? Defense?
That's right.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been signed, heard, and ruled upon by the court?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 1 year. There'll be a TAP evaluation and no contact with Patricia Garza. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes,
Then to the lesser included of offense, how do you plead? Guilty, not guilty, or no contest?
no contest.
State, any evidence?
Yes, Your Honor, state up for State's Exhibit 1 and its attachments.
Any objection?
No, Your Honor.
Showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes.
Have you all spoke to the complainant?
We have. Yes, we have spoken with the complainant.
And is she aware of this and in favor of this?
At the time when we finally finalized the plea, we had not been able to reach the complainant. She was previously non-cooperative.
Okay. All right. Are you still with the complainant?
No.
Do you have any children with her?
No.
That relationship is over. You're not to speak to her. Do you understand?
yes, sir.
If you violate my conditions, that we're going to have issues. Do you understand?
Yes,
All right. And with regards to the broken television sets, is there a restitution amount that's due for breaking 2 TVs?
There was no restitution amount included in the agreement.
All right. So do you know if there's restitution? People have to watch football. This is Texas.
No, I'm not aware of any restitution or any restitution asked for.
All right. So I see that alcohol was involved in this. If you're drug tested today, are you going to be positive for anything?
no,
All right. You can't be using drugs when you're working in the oil field. All
correct.
right. All right. Do you have any children?
I have one.
How old?
She's gonna be 5 this year.
All right. And is she in your life? Do you see her on a regular basis? And she's not with Ms. Garza?
No.
All right. The court is going to sentence you to 1 year deferred adjudication. There's an affirmative finding of family violence, the BIPP course, no contact with Patricia Garza. I'm going to do 80 hours of community service restitution. I'm going to order parenting classes. Once you've completed those, then the 80 hours will be satisfied. Regular reporting by Zoom or in person. Do you take UAs for your job? I know some do when they work in all fields, or is it only if there's an accident?
I believe it's only when it's an accident.
All right, we're going to do 90 sober meetings in 90 days. I know you are in the all fields, but sometimes they can have you do those online.
Right.
How are we going to handle the UAs? Because he's 2 weeks there and 2 weeks back. So he'll need to be tested when he comes back. So we'll do regular UAs, proof of employment within 15 days, no employment as a home health care provider or with minors. Probation, is there anything else? Let's just, they can do a field visit 2 times. And I want one done when he's first back in town to make sure that everything is okay. And then if everything is okay, they can do one more, just a spot check, random. All right, is there anything else you need from the court to be successful?
No.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. I'll give Tom Brown. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, sir.
Because anything else?
Yes, sure.
Yes.
Apologies. For his travel, I don't know, it's in Texas, outside of Texas, either way, can we get directed from the court?
Yes.
Or that permission, please.
All right, defendant is allowed to travel for work.
Thank you, Your Honor.
And my understanding, he says it's in Midland. All right. Did you review the document entitled trial court certification with your attorney? Did you understand it?
Yes, ma'am.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
And because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. You understand?
Yes, sir.
All right, we can go off the record. You're gonna have to do better. You gotta be an example for your children. Obviously, you cannot drink in moderation, so just don't drink. There are plenty of other drinks out there that are non-alcoholic that taste just as great. And did that neck tattoo hurt?
Yes, it was very.
Because it appears like it's right on the Adam's apple,
Yeah,
and the eye keeps moving.
with my tongue.
Yeah. All right. All right, good luck to you, okay?
Thank you, Your Honor.
All right, can I see the parties on Juan, Antonio? Yes, thank you so much.
Thank you.
And you just need to talk to probation. Could I see the attorneys on Juan Antonio Garcia Sanchez? All right, we're back on the record in 2019 CR 6322. The interpreter has previously been sworn. You're still under oath to faithfully translate. We received the question from the jurors. The question is, we are in dispute regarding the counselor's testimony. Did Mia tell the counselor about the alleged abuse after the outcry? The court proposes to send this back from the court reporter. Question, do you know when those allegations came about within the timeline of your visit with Mia? Mr. Leal, I'm going to object to personal knowledge, and whatever response she's required to answer is not based on personal knowledge. Mr. Banks, Your Honor, the court overruled. Question by Mr. Banks, you may answer. Answer, when she came to me and told me about the abuse. Mr. Leal, objection, judge, hearsay. The court overruled. Question, you may answer. Answer, and then the mother reported to the police officer, Mr. D. Feliciano, and going forward, when she went for her pelvic exam, gave a urine sample and blood was drawn. Any objections to that being the answer, state?
Objection, Your Honor.
Defense?
I'm gonna object, Your Honor. I think the answer should be no.
All right,
We agree. The answer should be no, not sending that.
all right, so you object to sending this back.
Yes.
All right, so that objection will be overruled. Any objection to, you all have overruled that objection, but any objection to the court sending back this answer, or would you like the jury to be brought out?
For those two.
State has no objection.
Yeah, just send it back. I mean, we don't have.
Without, right, without taking away our objection, just send it back.
All right, and the court notes your objection. All right, thank you. Yes. Oh, we're done. Thank you.
Judge, concerning,
Just 1 second.
concerning the launch schedule, just kind of like to give my own.
Oh, you're all on call. The jury lunch has been ordered for the jurors.
And Judge, I just need the key to vote, just to get the card out and go for the lunch.
Okay,
Time out.
yes. So we're off the record.
Thank you.
So you all will be on call, but go have your lunch. Just make sure that you're in walking distance of the courthouse.
Do you have suggestions, Judge?
Oh, well, of course, there's the cafeteria. Their grilled cheese is very good. Then
What about the beefs that you mentioned this morning?
oh, you know what? That is right across from where Frost Bank is. I think it's called Pinkerton's or something. And they have a nice little outdoor area.
Is that good?
Hmm?
Is
Yes.
that good?
Oh, yes, it is. The ribs are very good. So is the sausage. They have a duck jambalaya, which people are impressed with, but I'm from Louisiana, so
That's where you're from, right?
yeah. So if you want the people who are not from Louisiana would think the duck jambalaya is excellent, but it's out of a 10, I'll give it a 7. But I think you would like both.
Okay.
And they, I don't like, what is the barbecue meat here that everybody does? Yes, brisket. Thank you. I'm not a brisket fan, but everybody who's had their brisket, they say it's a 10 out of 10.
Really?
Yes. But it's right across the street. I think that's Houston is right across the street from Frost Bank.
Hey, Judge, I have another case. I don't know. if-
Trinidad?
Sorry?
Oh, I'm sorry. We're done. Thank you. Yes. Who's your client? Trinidad?
Trinidad.
Yes, are we? Yes, what's happening? Bring Trinidad down. So after Trinidad, it will be Gunner. What is happening with Trinidad?
Well, Judge, this is the first setting in the case, and I have some.
And you're in jury trial.
Right, and I'm jury trial and all of that, and so,
All right, so we'll bring it back on June 15th for discovery.
all right.
Okay.
Thank you, Judge.
You're welcome. All right, Thomas Jeremy. Trinidad is gonna be June 15th. Yes, we'll take up Jeremy Thomas. Jeremy Thomas?
Yes, ma'am.
Oh. All right, and this is no application. Court is calling 2023 CR 2285, State of Texas versus Jeremy Thomas. Can I have parties announced for the record for the state?
Lindsay Shaw for the state.
Defense?
Your Honor, good morning. Frankie Sandoval on behalf of Mr. Thomas.
Good morning, Mr. Sandoval. It's always great to see you.
Well, thank you, Judge. I'm humbled.
I'm going to show you what's entitled True Bill of Indictment. Mr. Thomas, did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, ma'am.
Mr. Thomas, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Did you understand you're being charged with evading arrest of detention second or more as a state jail felony?
Yes, ma'am.
Range of punishment is up to a $10,000 fine and anywhere from 180 days up to 2 years in a state jail facility. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe so, Your Honor.
Mr. Thomas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review it with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 1 year in the state jail facility and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contact.
State any evidence?
State of States Exhibit 1 and all attachments.
No objection, Judge.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review this document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right. Waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, in the interest of justice, there's nothing prohibiting that from occurring this morning.
Anything you wish to say on behalf of your client?
Your Honor, we had one previous setting before coming in and before taking the plea today. I don't want the court to think that that was because of Mr. Thomas not accepting responsibility. It's just logistics prevented us from being able to take the plea at that time. Mr. Thomas is here accepting responsibility and wishing to begin the process of putting this behind him.
All right, Mr. Thomas, why do you keep running?
This was actually my first time ever being actually charged with it. The first time was in Fort Worth, and that was dropped to a PI, public and talks.
No. This is
Yes, it was in Fort Worth. I remember it very correctly. I spent 30 days in the county jail up there.
no, what I'm telling you is what I have before me. I have a
Yeah, and
document
I don't know why it's the second one for.
that says evading arrest detention.
Yes, ma'am.
And that's when I believe it was assessed as a misdemeanor. Do you not remember that?
Yes, ma'am.
All right, so that's why you're here, because this is your second evading.
I never ran before. And I don't know why it's saying that for.
No, it says,
Yeah, and it states February, it states December in
No.
Fort Worth.
out of Tarrant County, Texas, it
Yes,
says,
that's Fort Worth.
yeah, I'm telling you what it says. The judgment says evading arrest detention. That's what the judgment says. Is the judgment incorrect, anyone? State or defense, do you think the judgment is incorrect? Because I just go by what the judgment says.
Yes, ma'am.
And what the judgment says, it's an evading.
As presented, Your Honor, it is.
All right. So, Mr. Thomas, you're gonna have to stop running because you're gonna keep picking up charges. And you picked the wrong street to run on in San Antonio. Fredericksburg is one of the longest streets in San Antonio. I learned that by taking the bus. If you're ever lost in San Antonio, you find Fredericksburg Road, at some point, you're gonna run into the cross streets. So, is there any mental health issues or no?
Not that we've discussed, Your Honor.
All right, have you ever been diagnosed with anything?
PTSD. I'm a US veteran.
All right, so do you know what's going on here today?
Yes, ma'am.
All right. Is there anything in his past other than the evading?
Let me take a look. There was a possession of marijuana in 2018 in Hood County. There was also an arson out of Bear County and recently in 2022.
All right, and what happened with the arson case?
He was sentenced to 4 months.
Okay. All right, I'm gonna find you guilty, send you to 1 year in the state jail facility, give you credit for any time served. I don't know what else is going on with him. There appears that there may be something else going on with him. So I'll request the therapeutic community. If you don't sign up for it, they're not going to give it to you. But if you do sign up for it, it doesn't increase the length of time that you're at the facility. Do you understand?
Yes, ma'am.
All right. Did you review the document entitled trial court certification with your attorney?
Yes,
Did you
ma'am.
understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you, okay?
Yes, ma'am.
Thank you. Do you need us? All right, so. Before we go on the record, the court is in receipt of two motions. The first is a motion for a new trial. And the next is a motion to withdraw. Is that correct?
Yes, Your Honor.
Okay, so the court is going to go on the record in 2018 CR 9130, State of Texas versus Kadir Gunner. Could I have parties announced for the record for the state?
Ruben Herrera for the state.
Defense?
Fernando Cortez and Zamora for Mr. Kadir Gunner.
All right, and are you Mr. Gunner?
Yes, ma'am.
All right, defense has filed a motion for a new trial. Have state, have you had a chance to review that?
Yes, Your Honor.
And defense, it is your motion. You may proceed.
Judge, we've already handed over the case that we're relying on, which is Valdez, the state, and we'd like to present the thing to the court judge. And we kind of highlighted the part we're focusing on as this is the directed verdict issue. And that goes to the sufficiency of the evidence to support the conviction. It is our position, Judge, that it would be insufficient evidence to go forward on this sexual assault where the manner and means of the assault involved physical force and violence. If simply there was testimony by anyone really, but particularly the complainant, that there was force used without any evidence of actual force being used. Here, the case law we've given the court is a directed verdict motion taken up on appeal and a sufficiency of evidence issue. And the court looks at it and indicate that it was sufficient because the complainant indicated that force was used, so they used the word force. And then the evidence showed that there was, during the sexual act, the alleged victim was held. There was a holding on to the victim, and the accused was on top of the victim. Those two issues, along with the testimony that force was used by the complainant. And that was found to be sufficient. So we would argue then the inverse would be logically true, that if the complainant indicates by their testimony, like they did in this case, that no force was used and no physical violence was used, she testified to that very clearly. And the detectives and to the detective and investigators further testified that there was no evidence of physical force or violence. But I think the key here is that the alleged victim or complainant herself testified that no physical force or violence was used. So if the complainant testified that force was used, then I think only a small amount of force is required to be legally sufficient to present that to the jury so that they can find it beyond a reasonable doubt. If she uses the word or a witness uses the word that force was used, here then the inverse should be true. That if the alleged victim indicates that no force was used, no physical violence was used, then you need a greater degree of force. So, for instance, the shifting of sexual position where her legs moved behind her, for instance, or maybe even turned around or anything like that, where there's a shifting of the sexual position involving just a shifting, really, that's all it is, physically, of positions. That by itself would be insufficient. It's not sufficient then to allow this case to go forward to a jury, and the directed verdict would be the most appropriate thing to grant. And here we have that situation where the alleged victim indicates that there was no physical force or violence used. The detective indicates there's no evidence of physical violence or force used. And so then we're left with what are the facts that show physical violence or force is used. And we really don't have any. The most you would have is that There's testimony that her legs were positioned behind her maybe. That he put his hand on her back, but that's not enough. When there's an absence, and actually there's testimony where she testified that no force was used. So if there is testimony that there's no force used by the complainant, then there has to be a greater degree of physical force used to overcome the sufficiency of evidence issue in a directed verdict. And our position is with the case law that the court has in front of it, there is testimony that physical violence, that the force would use. And then since there is testimony that force would use, it doesn't require much force then to support that. So there would be sufficient evidence to support that means and manner of conviction involving physical force. But then, like we argued earlier, that if the alleged victim had simply said that force was used, and then you have no evidence of physical violence or force, that would be totally appropriate for a directed verdict. Here we have, in fact, the opposite happening here, where the victim is saying no physical force or violence existed, and she testified that it did not occur that way. So then we argue that you would need a greater degree of physical force exerted during this physical act, this sexual act. And simply shifting position sexually where her legs are moved or anything like that, that's insufficient. And we would argue the court to consider that in our motion and grant our motion for a new trial based on it.
All right, state.
Your Honor, the state's argument is based on another case that we will present to the courts, Gonzalez versus State 2 Southwest 3D 4/11/1999, wherein the court states that, and I'll quote from the case, Smith testified that the appellant threw or laid her back on the couch. He then laid on top of her, preventing her from moving. Because of his weight, Smith was unable to move. There is no requirement that a certain amount of force be used, only that it is used. Your Honor, in this case, the complainant testified that when the allegations began, the complainant and the defendant were sitting in the front of the restaurant at a table when the defendant guided her to the back room where the alleged sexual assault occurred. Now, the state's first argument would be that the defendant placing his hand on her back to guide her to the back room where the sexual assault occurred is force by coercing her to move from one area to the back when he knew what his intentions were and when he intended to sexually assault the complainant. However, based on Gonzalez, Your Honor, the state would also argue that the complainant did testify that she was placed on her back on a rug, which was located in the back room, and the defendant was on top of her when the sexual assault occurred. Based on the analysis in Gonzalez, Your Honor, and based on the fact that there is no requirement of force that be shown by the state to show that that there was physical force or violence, the state would argue that based on the precedent that there was enough testimony provided by the complainant that the defendant did indeed use physical force to commit the sexual assault. And because the evidence is viewed in the light most favored to the verdict, Your Honor, we'd ask that you deny the defendant's motion for a new trial based on the evidence that was provided at the trial.
All right, defense, it's your motion, so you have final argument.
Judge, an interesting point that the state just brought up on the issue of coercion. Coercion is a manner and means to commit this offense, but the state did not allege that in the indictment. Because they did not allege that in the indictment, they cannot now use that for a conviction. They're actually prohibited from doing that. So the state elected to exclude coercion as a manner and means of committing this offense. They cannot now rely on that. They're prohibited from exactly doing that because they excluded the manner and means involving coercion. Now, if you listen to what he just said, this person was thrown on the ground, that's violence, thrown. And then the victim was laid upon in such a manner that prevented her from moving or leaving or doing anything other. She was prevented for certain action.
So throwing and preventing are certainly two aspects of physical force that would detain someone. Those elements are completely missing here. There is nothing saying that she was thrown on there. He said she was laid down. That's not physical violence. And that he got on top of her, but not to the point where she was restricted from leaving or moving or anything like that. There was no testimony. So there is no testimony supporting even the case law that he'd mentioned, and particularly on the issue of coercion, which was not alleged as a manner of meeting the indictment. They cannot now rely on that.
Okay. All right, thank you so much. Mr. Gunner, I want you to know that your counsels filed this motion. So I did have a chance to review it before everybody appeared. In this court, when people file motions, it can be motions that are regular motions that everybody file. I still take my time and read through them and make sure that I know the law as it relates to it, whatever is being filed. And then once I know the law and make sure that I know the law, then I let both parties have a chance to argue. And I keep an open mind. So I want you to know that even though I had previously reviewed the motion for new trial, I didn't review it with an eye towards granting or denying. I just reviewed it to make sure I know what your counsel is asking for and what their argument is. And then I think potentially about what the state's argument is going to be. So I never make up in my mind a decision about anything until I hear argument from both sides, okay? All right, so I've had a chance to hear both parties' arguments, and I've had a chance to review counsel's motion and review the case law. And so I am going to deny the motion for new trial. With regards to the appeals bond, did you want to speak on that?
Well, just if I may, the jury did come back with under 10 years. Mr. Kadir's a local businessman. We can surrender his passport. We would ask the court to grant an appeal bond while this is pending.
All right, that will be denied, and I'll deny that based upon Article 44.04 and what that article entails. So that will be denied. The next case we have, the next thing we have is a motion to withdraw. And is that for both councils?
It is, Your Honor.
There's two different motions.
So, Mr. Gunner, are you aware that the attorneys are withdrawing? Withdrawing from your cases, are you aware?
Yes.
All right, do you have any objections to that?
Judge, for the record, the family had hired Dana, who was here on the appeal.
Okay, so an attorney has already been hired for the appeal on this case. Do you understand?
Yes.
So the trial attorneys, I'm going to allow them to withdraw. Do you understand?
Yes.
Okay. All right, is there anything else from either side?
No, Your Honor.
All right, thank you all for your patience. It's been a busy Monday.
Thank you, Judge.
All right, thank you.
On the lie, I thought maybe I agree.
I know.
Thank you.
Well, I tell you what, come back tomorrow. We should have some here.
Thank you, Judge.
All right.
Judge, I had that just like,
No, I mean, I'm telling you, it's not.
it was like, rice was broken, that was it.
Yeah. Pedro Alonso. Oh, we're waiting for food. Oh, it is? Yes, don't leave, just stay and I will write that. Okay. All right, and then after this, everyone, we're gonna take a break. Yes. All right, so what is happening with this case?
So Judge, our understanding is that the
Federal feds will be picking this up. Are they not picking it up?
they are not picking it up, Judge, so I did make an offer.
All right, so do you have all the discovery?
Yes, Your Honor.
All right, because we were waiting on that, I'm gonna have this recalled just to be sure that all discovery, everybody has all the discovery. I'm gonna recall it for June 15th. And then there's gonna be a quick turnaround for a plea deadline date. And then if your client chooses to go to trial, then we'll give you a trial date. So we will be back on June 15th.
I have a federal court sentencing on the fifteenth.
And look at that, federal court takes precedent. It does.
I'm sorry, I just like
No,
to.
no,
clear
no,
that
I'm
up.
glad
It's,
you let me know. So instead of the 15th, we'll bring it back then on June 12th. All right, so we'll come back on June 12th.
Is June 14th available? Federal, I'm sorry, I do have also on that.
What is happening on June 12th for you?
Also federal court has some police and federal court.
June 13th.
I'm also. federal court, June 13th.
All right.
June 14th, I have absolutely not.
All right, let's do this. Let's bring it back on June 5th.
June 5th is good.
All right, Caroline, this will be back on June 5th.
Thank you, Judge. Sorry about that.
No problem. I'm glad you let us know, so we won't be waiting.
It stresses me out trying to be in two different places at the same time.
Who's here on Christopher Reyes? Come forward. And we are off the record. All right, so today is, where is Christopher Reyes?
He's here. He's behind me on the right.
All right, Mr. Reyes, come forward. So today is his plea deadline.
It is.
Mr. Reyes, come forward.
Here.
Hi, okay.
I'm sorry, he's.
You're blocking him, Mr. Bach. Hi, good afternoon. So today's plea deadline day, what's happening?
We got a new plea bargain offer today. I'd like to see if I can have 1 week. I'm coming back with Mr. Dominguez on Monday. I'd like to just give this gentleman until Monday to make a decision on the offer he received today.
Okay, so we'll be back then on the 22nd.
Yes,
All right, Caroline, can you give him a reset date of May 22nd? All right, that will be your final plea deadline, date, okay?
thank you, Judge.
All right, thank you. Mr. Bach, I told everybody the beignets where you were, Cafe Du Monde, that hot chocolate is carnation hot
It
chocolate.
is, but it's still good. Let's see, you'll sign this up. That's some good food, lots of it.
This is why I cannot diet successfully because I'm from Louisiana.
There's no way.
No, it can't be done. All right, is that everyone, Caroline? All right, well, we're taking our break. So we will be back